Good evening. We, the unwilling, led by the unknowing, are doing the impossible for the ungrateful. We have done so much for so long with so little. We are now qualified to do anything with nothing.
I'm ordering you as a condition of your bond not to participate in this kind of behavior again. find that you become a danger to our community, I have one place for you. I will revoke your bond, put you in jail, no more PR bonds. You missed court yesterday. We issued a warrant. I will reinstate your bond today, but this is the only get out of jail free card you get. You miss court again, I will revoke your bond, no more. Do you understand?
Sorry.
It is your responsibility to know when to come to court and when to show up. We have given you a lawyer. It is also your responsibility to stay in touch with the lawyer. If he tells me he can't get a hold of you because you're ducking and dodging, likewise, I have one place for you. Do you understand?
Sorry.
So can you file no contact, no weapons, please?
Yes, Judge.
Here. Hey, look, put it again.
Judge, well, that's it for now. We're waiting on the attorneys to show up.
Do you have any THAs?
No, Judge. Council for reset. Yeah. See? Okay. Judge. There's
Thanks, yeah. I'm not gonna get anything in return.
well, maybe.
He's lying. He's lying.
Do you want some of these? No? No.
It's not.
I know mine's. She's a problem.
Which one?
No.
Milk gets eaten, man. Come on. It's like pulling teeth.
It's like. Hunter, Jerome.
Oh, I like it. You want to put it on here? Is that Paw Patrol? Yeah, I like it. Chase is on the case. Mr. Lott.
Yes, good morning.
Good morning, sir.
Yes, sir. I'm here on a Ramon Delgado Ciceros. I
Okay.
have, it's a 25357-130.
Instead of reset dates to choose from.
So Victoria emailed you a set of reset dates for you.
Okay. I'll take a look at that.
Well,
and
hold
get-
on. Since you're here, I'll just get a date.
Okay, that'd be great.
March 25 through the 27th.
March 25th through the 27th.
One moment.
Is discovery complete, Alex?
Let me check, Your Honor.
Delgado.
No, Judge, it's not.
No, I'm still waiting on videos.
27th would be great.
Okay.
It's getting kind of old, so I guess by the next time, if this videos aren't here, we're gonna have an issue. So
Yes.
just, okay. All right, we got you.
Okay, Judge, thank you.
It'll still be waived for the next setting as well.
Okay, thank you.
All right, take care. Oh, no, it won't. Yeah.
No, he's a chief. Yeah. Okay.
Hey, you want another one? Let me pull this out. It'll be easier for you to do. Wow,
I'm old.
that's nice.
You're with Ashley. No, you are invited.
Oh, bless you. You okay? Here, you can put more stickers right there if you want.
Christopher Appy. Christopher Appy. You know why you're so involved? You know what you do all the time for your life.
Yeah, I still do.
Yeah, roll. See if you can stick it back on there. Look. Put right on, right where it's, yeah. That looks good.
It was the last one.
You want to do another one? Which one? Oh, you're turning.
Yeah.
Oh, I didn't know that. No, not on me. There's no more room in me.
Walking.
Another sky?
There was guy and cake.
Shot is Sky and Chase?
Yeah.
Oh, right.
Marshall. Marshall.
Who's that?
Marshall.
Marshall? Okay.
Marshall.
Marshall's on the case.
I fired up. Marshall said, I'm fired up.
I'm fired up. I'm fired up. There's another Marshall. All the way to the side, all the way to the end. And then we turn the page like this way, all the way to the end, like that. That's right here.
Okay.
It's not-
Bringing to. They're on no. Oh,
Mr. Elick, you ready?
Yes, Your Honor, may we approach?
Yeah, of course.
We have an MAJ for Miss Salazar today, and we're kind of talking. I mean, I think last time, y'all were at maybe time served.
And that's what's thinking.
I'm okay with that. I mean, but that's
She's, I mean,
does she want to do it? That's the question. Because last time she
she
didn't
didn't
want to.
want, right. I mean, she doesn't have court until March 11th. She has a month of credit. And I mean,
What do you want to do? You want to do it? I'm game.
I mean, it's her choice.
She has a lot of credit.
She does have a lot
They'd
to-
be willing to all the time serve. She's already.
The thing is that I think last time they wanted me to unset term, and I'm okay with it a lot of times, but in this case, we have just assault after assault after assault. We've already had a couple that have been dismissed, and I can't just continue to do it. Not when you're picking up felony assaults. It's just at some point, we got to say when.
Her grandmother wrote an affidavit. I had no part of it. I don't know if you'd be willing to look at it. I know the state said they wouldn't. I mean, I know it's not admissible in rules of evidence, but
I mean,
she led to basically opening the door and hitting her grandma, which I don't even think she knew her grandma was there.
she what?
So the injury to the elderly is what she's undeferred for, what she pled guilty. That case, she was
Against grandma?
was against grandma, and she had an infant, and for whatever reason, there was an argument, and she was like, I'm leaving the house. And grandma was like, no, you're not leaving. And, I think she didn't even know grandma was there. She opened the door and then allegedly hit the grandma. And her grandma wrote an affidavit basically saying,
I
I understand.
understand, but I just nevertheless, we still have, and I don't even know what happened in the felony case. What were they alleging?
So, Your Honor, in that one, officer dispatched an assault. Complainant one is the defendant's grandmother who didn't complain on the case she pled to. Complainant one and defendant got into an argument over care of the defendant's child. The defendant was outside the back door, and complainant one was standing in the doorway when the defendant pushed the door hard, throwing complainant one to the ground, causing pain. Complainant one is 80 years old. Officers observed 80. That's right. Officers observed injuries on complainant one's arms, or arm. Defendant then left the scene and went to her house where complainant two was, and there was another allegation.
You're just lucky that it didn't sustain any, serious. And you're 80, you're falling down.
Well, I mean,
Grandfather broke his hip like that.
I mean, she just basically said she left angry, slammed the door. She didn't realize it was holding the door. I lost balance and fell, and she's basically saying, yeah, she didn't even know.
I don't know.
I
If
know.
you
She's not
don't
here.
do the time served, we can do it. Otherwise, we can just go through
Just
with
have
the
to-
hearing.
Okay.
You know, it's up to you guys.
Let me go, if like, and what time do you think we should start? I know the probation
Well,
officer's in
And I
another.
would probably postpone it to later in the week because I've got him with me now and,
Yeah.
you know, just he's sick, so I couldn't take him to school. So, I mean, it would be like later this week.
So tomorrow or Friday?
You want,
Can I offer just something? So could we maybe, and I, defense this is up to you, can we maybe bring her out to have her admonished on what's going on? Just see where we're at to try to see if we can get it resolved. If not, then we can go
Sheila?
for the hearing.
I can go talk to her and I don't have a problem with that, but
first, let me go talk. If she's down for taking the time served today, let's just get it done and move on. She can concentrate upstairs. Otherwise,
would it be Thursday or Friday?
and we can go forward on a technical.
Yeah,
That way it doesn't kind of,
yeah.
you know.
Well, and the new felonies have been resolved, so.
Oh, they have?
Yes, Your Honor. It's,
Yeah.
there's a deferred, on the injury to elderly, the other case that was alleged and dismissed as part of the negotiations. So from our perspective, we have a JNS.
So really it's,
I know.
okay.
I'm just
Let me know what-
seeing what I can get, but yeah.
I understand this.
I mean, I feel like I have house money to play with and nothing to lose. Maybe it's a long shot, but
If you need to go with the hearing.
let me just talk with her and then if we did have a hearing, would it be Thursday or Friday or? Okay,
Monday? Monday.
okay, I'll be back, Your Honor.
Thank you.
Thank you.
Just brief question, if you have a second. So as far as I know, with MAJs, typically you have to get an order from you to get the probation file released. I don't know how this court likes to handle that.
Say it again?
You already do, okay.
Okay.
Okay, that'd be perfect. Thank you, Judge.
Of course. State officers here.
Yes. This is your turn, here's a little
How's it going?
Same game, so it's a mini game inside the yes. So any options.
I thought January blood story a while ago. Today or? January 15th. Yeah. 25, 6, yeah, that's great. David, yes, sir. I appreciate you. Checking. All right, 6 minutes. Yeah. No, no, no.
I'm just gonna put percent
Those
statements.
On that case.
Not with Mrs.
City establishment. But he never goes.
Okay. Oh, this is how it's all, this is all of them. Yes. How's it that it is one?
So I'm gonna.
So like he's allowed to work. And like. What's the short example? She's like taking her arm and besides.
Yeah, I think it's.
She's just like.
This is a. Judge, I had a GPS.
That'll be which means.
You need to let Neelick know that she's here and ready for the hearing. The probation officer, like she's here ready to testify, so he needs to like take it or.
Go back there.
Yeah, he's talking to her now, but I guess we need to let him know that, you know.
Nope, he was talking about it first.
It's too, tables. They are.
Yeah, no, for sure.
He's creating so.
I mean, hopefully they all get it, but. Okay. I'm not sure.
Yeah, that's good. I appreciate it. That's annual. I will leave it.
Hopefully that.
How much is it?
Is discovery.
Okay. Yes. One piece of body that don't change. So it's this right here, that's enough. Now you're gonna email those.
Yeah.
I'm still gonna do it today.
Yeah, so you know now.
Okay. All right, how is March 19 or 27? All right, waived appearance pending discovery. You too, bye.
Yes. Again. Oh, yeah.
It's crazy. There's funny, I don't believe I know this. It's like studying criminal. Let's have a look. Bring a string back to back. Let's go find it. Okay, okay, so this one's 180 pesos. Just know that that one now. That's you. I don't even know. It's dead right now. Yes.
Yeah, it's we get it.
It's been 50 and one say. Doesn't hold those big.
Yeah.
Yeah, but it's I think it was
Yeah, no, I think it's actually. Yeah, I was trying to figure it out.
Yeah. What's up, guys?
Good morning, Your Honor.
Hey, good morning.
I'm here on Moses Pena.
Okay.
It is quite old, but we finally figured out the problem. It was an order that was not sent to DPS. So he's going to send that as soon as he leaves. So we kind of put the pieces of the puzzle together.
Anytime you get DPS involved, it takes weeks to months for anything to happen though.
It's so
So
sad. It's so sad.
like we're at 190 days.
I
So
know.
I mean, I can't keep it open for another 3 months waiting for
Nah.
DPS to do.
No, 30 days max, maybe even 2 weeks. You know,
You want to do, what's the,
as soon as he leaves for DPS, I just want him to get his license reinstated. Because at the time that he had the DWI, the order for the removal of the interlock was not sent either by him or his lawyer. So for all this time, he's.
I don't think that they send an order for removal to interlock to DPS. I don't think it ever, one of those, they don't send those.
We send, once it's entered, we.
They
a
send,
copy.
you guys send
Yeah,
order
they
of
do.
removal to
But it wasn't
DPS?
entered till 2 weeks ago, and that case is before 20.
Right, well, I mean, someone has to come, let us know. Usually lawyers at the time when the case is over with,
Right,
when they
right.
plead or whatnot, they'll
Ball
get
was
it.
dropped. It wasn't my ball, but I just want to bring this
So
to
what
a
to
resolution.
get done for him to, has he reinstatement fees been paid?
All that's been done. The only thing that they're waiting on, because I even had him, go to DPS, something doesn't fit here. For 5 years, you didn't know your license was suspended. So that's when the lady at DPS said, we're missing this order. So once we finally figured out what was going on here.
You know, the thing is, though, is that even if we set it off 2 weeks, it will not reflect as eligible in 2 weeks. I mean, they're going to get it in 2 weeks. For them to enter it into the system, that'll take another 6 to 8 weeks.
Yeah.
Um,
The state has been working with me on this, and I appreciate it, but I understand that there's also a time frame for the
right, I
court.
mean, we can just keep it open for 6 months waiting for this, especially.
I'm not even asking.
So, I mean, we'll give you 2 to 3 weeks,
Perfect.
you know. Yeah, at that point, I guess we'll come back, see if it's eligible, great. If not, I don't know. We'll have to figure something else. Yeah.
Sounds good.
Okay,
Thank you, Your Honor.
you got it.
Appreciate that.
Take care.
Thank you. May I be excused?
Yes, sir.
Right, so 2 weeks brings you out to March 3rd, 3 weeks brings you out. Right. You can have ours. All right, there you go.
Thank you very much.
Council for reset. Hey, Barb.
Anyway. Did you give us a copy?
Still no, break eight, you'll hold us. Yes, yes.
Nobody knows. Nobody recognizes. You don't have glasses on. Still Richard. Used to the YouTube.
This is the attorney.
I know.
No, I thought you made.
Oh, no. Oh, the one?
Yeah.
She's not.
No,
It's a lot of different.
Yeah.
So a lot of times you say. I expect. Last year.
What do you think?
The DMV, I can never get it, 2 minutes, 3 minutes, 2 minutes, 3 minutes.
You try to ask him.
They're gonna take the comments, we don't need to be mad. And how would I be in that option? And please clear that. It's not cheap. It all. She's not.
So my business is
You gotta feel really bad. You can't see what. It's not saying any change.
Hey, come on up.
Okay. Yes, sir. It's going to be on Robin Parks on Docket. So I was speaking with her yesterday. She's having some transportation issues being here today. So I was going to see if we could set her for bond forfeiture, but I am in contact with her. So I believe all the discovery is in. We are waiting for an offer, I believe.
Yeah. Yes, Judge, all discovery's in and we can look at it and put it offer.
It's 200 days. I don't
Yes,
know
Judge.
why there's not an offer now.
I think it was a 2B for quite a while, actually. It's not. But it was some kind of.
Factor in the age of the case though, you know, what the age starts when they get on.
Oh, right.
So I'll set it for bond forfeiture for 1 week.
Yes, sir.
She's not here, I'm revoking her bond. And then you gotta be ready to play her trial at the next setting as well. If you can please put an offer. I'll-
Yes, Judge, we'll put one.
All right.
Thank you, Judge.
Got it.
Thanks, Al. Appreciate it.
Hey, Josh, Hey, Judge, can I give you a case number?
Yeah,
2533973.
okay.
Also appeared January 24th for his arraignment. These are now on the phone.
What's you think?
Judge, also, this was one of the ones that was reset because of the weather. And then
Come up, sir. Sir, you were charged of theft by check. You were facing up to a year in jail and or a $4,000 fine. Probable cause has already been found in this case. Do you have a lawyer today?
No, Your Honor.
I see that we have two missed court dates. Is that right?
Judge, the bond paperwork, put him to come to court on the day that, what was it, the 21st, which was the first.
I will give you the benefit of the doubt today and I will reinstate your bond, but it's not going to happen again. You ever miss court again, you will end up going to jail. Do you understand?
Yes, sir.
Okay, do you have a lawyer today?
No, Your Honor.
Okay.
I'm pretty sure I know what that case is about. It was
I
a,
don't want to talk about the case. You have the right to remain silent. Exercise that right. Anything you say here, they're going to try to prove guilt for you. You have the ability to hire a lawyer.
yes, Your Honor.
Okay, so we're going to reset your case to give you time to hire a lawyer. So I'll have you go to Victoria, get a reset, and then after that, we'll get you on your way. And when you come back, please have a lawyer.
Yes, sir.
Okay? All right, please.
There's no bond condition.
No, it's a theft by check. Is it the Ann Harris Bennett? Because that's what it looks like they've been used.
Your Honor, is there a cause number for that?
Yeah, sorry, 2533 973.
I apologize, 25397.
2533 973. Okay, so you reinstate the law. Yeah, it's a registration. I mean, that's what I see nowadays with these theft by checks. So-
Judge registration.
All right, that's it, you're free to go. It's highlighted for you. I saw your email cards.
Okay.
Or probably gonna pull up.
Hold on, step forward.
Because it on.
There are a couple of big offices. I know Eloise is not all. Hey, Joe, did you hear what he said? You're so interested.
Like you do nothing, so those who want to bother you.
They're like, I won't be here tomorrow, that's right, so I'll be in New York for work.
Where did I lost it? I did the opposite thing. Those are the. And then under the age of the things that are in the Chinese. I couldn't do it. They all was July. I went in there, but I just. No. Sorry, I'm sure. Yes. Let me think. I've read it a couple weeks, not like I did, is right. No. But it was from and this is what they're talking about. I'm very first, I'm putting all of these things, you know, has a lot of now, I feel like. It's so high. Not, it's not big. And you talk about it, I don't know. It's not, you're not, that's. I graduated. Oh, shit, that's easy. So really, people look so because I think for it. Here. They just can't, they haven't really want to go on. No, I. You want to go easy? Yeah.
What is that? Someone playing pool?
It's also the giant marble around.
Yeah.
I think better. Me too. Oh, I'm not. I would want people to where I start. Check them out of the flower. Because I wouldn't. No, I'm not. You knew what was on the shop. Yeah. It's Mackenzie's. I'm sure.
Okay. Yeah, cases. The evidence was or her statement. Right. Officers.
Yeah.
Pills. I guess it's Adderall. Right. And, like next to her, and then he keeps on. But you know, she's got this 2 people and stuff, so he puts her in custody. And, he, asked her, whatever the thing that's your name. And it's like, oh, last thing while she's asked you, but it hasn't been. Then you go to your back. And, doesn't feel like big, so I had to go there.
Sure, I've seen that's about.
Oh, okay, all right, so, did you guys, do you want to do the felony is going to be dismissed, she's got a few more conditions to finish.
Right, I see the conditions for validity. For PTI.
Yeah, that's it. Well, I mean, technically. Well, with the, I think yeah. Or actually, even sort of saying that like ownership of the gun, it's just like you wouldn't be able to argue one of these. The gun wouldn't be legal without it. So.
Choose to like this.
The drugs is it's like, she was.
Chicken. Chicken.
I don't know. That doesn't look like a chicken to me. Putting another lollipop in the cake.
The gun actually was.
Yuck. Hey, now a candy cane on the cake. That looks gross.
All right, you're saying.
Ooh, that's too much.
See, it's satisfying.
You want to try it again? No, look, you can put other things like you can put candles on it too.
Yeah, it's just like that.
Have it in a cube too.
It's also not.
Ramirez Luis.
Oh, yeah. Okay, Brad.
I choose black. I did it again.
I see. Mhm.
Wow.
Whisper.
That's fine. So I'm not supposed to, I just talk to her first. And then she shows it was.
Oh, we have a ton of trials for next week. Huh?
I know.
Ton of trials.
Let me talk to her, she used to with me. Yep, about it. But I don't. It is also the more time for them to 1 years old. I don't want to hold on to longer than we have to.
We're gonna jump around. I was more 19.
Yellow pig. Yellow.
That looks good. That looks good. That's what a cake looks like. What? No. Hit the X right there. There you go. Choose different, like you can put over here to choose something different.
So there's their done.
See, and go down. Those are other things that you can put on the cake. Hey, Alex, we have a ton of trials for next week. Do you know you're ready to go on and who you're not?
Pull up the trial document, a quick judging, let you know.
Like maybe 1, 2, 3, 4, 5, 6, 7.
Why's not going?
Yeah, pick one and then move it. I see that you guys filed a motion for continuance.
Yes, we filed on one of the cases.
Have you talked to the defense lawyer, see their position?
Okay.
I don't know. Did you talk to the defense about the continuance?
Your Honor, I sent an email. I haven't heard back from them. My goal was to get them to approach the
As far as the, with Jillian, you mean?
Yes.
Okay.
I haven't heard back from her. I asked her if she could come in one day this week to approach. But her issue is that a witness isn't available.
You get one continuance. That's it.
Yes, Your Honor.
So you get one crack. That's it. So if they come back. and-
Notoriously hard to track down and get in court, so I was.
Okay, but you know, like I said, like if you get a
Yes, and
on
I
a
did,
date and then,
be an ex parte, Your Honor, I did, when I called them, I made sure that the next day,
okay.
we did get good dates for them, so.
Got it. Okay, yeah, so let's just, I guess I'll wait for Jillian and we'll see what her reply is and then go from there.
Yes, Your Honor. Thank you.
Are you guys ready on everything else then? All the other trial cases, you ready?
Working on them, I just got this for yesterday.
Yeah. Okay, take your time. No rush. Yeah.
Your Honor, also looking at this case.
Hey, ready? Yeah, come on up. How are you?
How you doing?
Co-counsel's just, he doesn't listen. Other than that, great. How are you?
Well, we're approaching on Torres, Your Honor, Christopher Torres.
Okay, okay. What are we doing?
Well, this is where we're at is, I don't know what your position is on approaching without an agreed rec. That's why I'm approaching.
Okay,
Or how you work that, or do you do that?
yes,
Yeah.
yes, but not, no, I'm gonna time serve on a second.
Wait.
So
To give you some background, my client has a prior intoxication assault that he had a probation for. Yeah, in 2013. So he's completed that. And so this is filed as a DWI second. It's a 1-6. It was an accident.
The intoxication assault was the first.
I don't think he has any other criminal history, does he?
Not, double check. A class C public intoxication 2010, but nothing
In
else.
2010? Yeah.
Okay.
So this involved an accident, and the RIP call says there was just some damage and they just wanted to be paid for that. I submitted an insurance document to the state that showed that he had insurance and they were paying. And the thing in the RIP call, the guy says he hasn't been out of pocket it.
Okay.
And anyway, so the state,
Oh, not even, no deductible or anything like that?
So,
No.
and that's what the complainant stated that the insurance was supposed to be taking care of it. I don't have the information on the deductible. I can get that.
I want to make sure that, I mean, before we do anything, I want to make sure that this person is made whole.
of course,
I don't want to,
and I'm all right with the reset too, Judge. I'm not,
or, you know,
We talked to them on 2/3,
Yes.
and I can follow up today just to see what kind of out of pocket are we looking at? Did insurance take care of it? Which I would agree, they're probably the deductible.
you know, my concern is that we have a prior intox assault and now we have another one. So he's just not getting it. So how do we do that? We need to monitor him for a while to make sure that he understands what's going on and perhaps fix any issues that need to be, you know, potentially fixed. So I would say if he wants to do anything, you know, like do a TRAS, let's set him up for a TRAS and see what it says.
okay.
That's what I'd like to do. So, yeah, let's set him up for a TRAS because I don't, you know, it's concerning the intox
Yeah, I
assault. Now
understand.
this, let's see what a TRAS says and then we can go from there.
Okay, thank you, Ron.
Really like to follow the advice because those people usually really nail it on the head as to what we should do.
Okay, thank you, Judge.
Thank you, Aaron.
So let's set it out. Is he here now?
Yeah.
You want to send him now since he's here? We could do a walkthrough and then we can reset it like 2.5 weeks to get results. And then in the interim, that it gives him time to work on the restitution. You okay with that?
Yeah.
All right. Money.
Yeah.
Did you need me?
I just kind of think they're just trying to figure out how this. It's not the OR access with the explicit inspection.
Construction site. Yes. Yes, please.
All right. Yeah. Yeah, that's all. Actually, it's just.
So, on this case, look at the title and the witness. You call for 911. And that you don't get arrested. They retired. Yeah, that's fine. Yeah, it's on all.
So the new.
I thought the picture has to be clear.
Yeah. No, there was.
We're waiting for that.
We're gonna jump on with it. 13, 19, 27. That's like those are last question first, so maybe. And I do see that, today, door down. So in probation, you'll PCI and commission. Yeah.
Just got reading.
Yeah. I can offer that right now. I was a lot.
What, do you know?
I'll do it first off lunch.
This guy's 27.
Okay, next time if you want to do.
For the first one.
Okay, thank you.
You're welcome. Council for recess?
I'll check out.
So, when you said that,
Yeah.
I'll.
why do you say it's the way
You have to list those pieces.
you're gonna be going?
You got salt. You got salt. You already gave a reputation.
Okay, so that one,
Okay, cool.
Thanks, name is Jasmine.
All
right, how's? One is it.
Oh, okay.
Yeah, can I do,
Yeah.
yeah, we'll give it a break for a second.
Do you want to call them to sign?
All right, so we go get it.
That's gonna every time I talk, we more, so we have to do that. Council for reset.
Thank you. That's So you are.
Oh, okay.
3 years. He says, or maybe gone for? He gone for me a couple times, so I also it's not a problem, but. Not day. Comes around. Oh, 5, okay. All right. Spanish person I want she would be able to be part right now. I thought I but I know this, that I get on our house, like, that's see what he makes. Council for reset. I know there's also a surgeon. You're watching? Yeah. 3 years ago.
I get an opportunity. I could defer opportunity.
All right. Tomorrow. Thursday.
Yes.
Well, no, it doesn't.
Council for reset. I'm gonna try not to. Sounds very.
Yeah, especially that also that.
Connor.
Judge, I'm approaching on Coriel Dixon.
Okay.
The state's offered, instead of doing the full GED course, to do a decision-making class. She's indicated to me that she does want to, keep pursuing the GED stuff. But like we talked about before, she's kind of having to learn all of high school, right?
Sure.
So talk to her about it. She wants to do the class. She's asking for 1 week to get it done.
So the top of page 7.
Yeah. Zero. Yeah, I know.
Okay.
I know. It's okay. Yeah, we'll give you the week for sure.
Thank you, Judge.
Yeah.
How much? 1 week?
1 week.
Okay, so 1 week is ready to have to February.
Hey, John.
Hey, Judge.
What's
Thanks
going
for
on?
picking me up.
Say it again?
Just need to, want to talk about Guzman, the guy that we approached last week. And his felony was yesterday, and it looks like they rolled it to the 12th. He was the guy with, on a probation on our WI and up a new drug case.
What's the last name?
Guzman, in custody, Judge. G-U-Z, Guzman.
I guess you will carry it to the 13th, the day after the felony court. What do you think?
Yeah, that's what I was asking for. The other thing too, Judge, is it looks like he got some sort of bond on the felony. Because when I looked at Jim's, it looks like the bond was made. The only thing that was outstanding is our $10,000 bond on of course, on the probation case. I was wondering if maybe you would consider lowering that.
No, not for Mr. Guzman. He's a flight risk. He never shows up. He does whatever he wants to do. If once he gets out, I don't think we'll see him again. He's shown that over and over and over. That's why we have it at 10,000.
Okay. Okay. Then
Oh,
we'll
give me a
just roll
second.
it
Give me
till
a Did we do a new TRAS on him?
They came this morning. She said she should have it done by 12.
Okay, we did a TRAS on him, John. We're waiting for.
Right, I remember. I mean, we fought hard to get him the whole because he had a UCW that we worked out. So I mean, it took a lot of work to get him that DWI probation. I remember that.
So
Yeah.
feeling is we're probably going to want to do residential. My feeling is they're probably going to want to do residential, John. The only problem is the case upstairs because that kind of like puts everything on hold. And
No, I understand, and I will check upstairs and see if we can maybe work something out with them because it's Rick Court, Judge.
Okay, is he in Rick Court up there? Yeah. Okay.
Yeah. So let me just have some time to reach out to the people up there and his felony attorneys, and we'll see if we can put something together for the whole thing.
Do you want to set it out?
Okay, so that'll be on the
So, John, when do you want to set it? Do you want to set it the day after the felony court?
Yeah, that's fine. The 13th is fine. I think his felony is reset to the 12th.
Right. And then in the interim, when we get it, I guess,
Send it to all the citizens.
and to me too, because I'd like to see it as well.
This is the probation officer for Samantha Salazar, the MHA here.
Got it. Okay, give me 1 second. Let me just finish with him real quick. John, I have an arraignment with you real quick.
Yeah, we have I have Mr. Hunter and also me.
Well, who's the arraignment, Vic?
So the
Please.
arraignment is on, let's see, page 17, Lopez, and he's here.
Brian Lopez, come up. Mr. Lopez, you're charged with violation of a protective order. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The complainant and the defendant are in a previous dating relationship, and on October 1st, 2024, the officer was dispatched to a holdup alarm call at a residence in Harris County, Texas. Or I apologize, at the complainant's place of work in Harris County, Texas. The officer made contact with the complainant who stated the address was her place of work and that the defendant was outside her place of work causing a disturbance. The complainant advised the panic alarm was used for this incident. The officer met with the defendant who was emotional and possibly hyperventilating. The defendant refused EMS treatment and the officer performed a person check on the defendant, observing a family violence bond condition out of Fort Bend, the 400th District Court, which prohibited the defendant from attempting to contact the complainant or having any threatening, abusive, or harassing contact. The complainant stated the defendant attempted to bring her flowers and attempted to speak with her, and the complainant stated she would not speak to the defendant, and the defendant said that because the complainant would not speak with him, he was going to go get a firearm and shoot himself on scene to make her suffer by making her watch. The complainant stated she believed the defendant's statement to be harassing.
What does he have open now?
So he has
You run an NCIC.
on the floor at NCIC, Your Honor. So it looks like he has an AFM out of Fort Bend. He also has an interference with emergency request for assistance out of Fort Bend.
Both of those open at this time?
Yes, Judge. And then it appears he also has a VPO out of Fort Bend.
That's also open as well?
No, I apologize. So it's just, all we have is just the AFM and the interference. Out of
Do you
Fort
have a
Bend.
prior violation protective order as well?
It was rejected, Your Honor. He does have a fail to ID open right now at Fort Bend as well. So a fail to ID, an AFM, and an interference.
Mr. Lopez, I'm going to find that there's probable cause to go forward with your case. I'm entering now what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. De Leon as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand? Yes or no? Let me make something abundantly clear to you, sir. The Texas Constitution does not allow me but in extremely limited circumstances to have a hearing to hold someone at no bond. This is one of those occasions. You violate one of the conditions here, I can have a hearing to hold you at no bond, and I will do it in a heartbeat to protect every person in this county. You're forbidden from going within 1,000 feet of where she lives or where she works, and I'm putting a GPS monitor on your ankle so I know where you are at all times. Do you understand? You are not to consume alcohol, illegal drugs, not to be in possession of any weapons.
Were there any offers?
Brian, this is Attorney John. I don't have a number for you, so before you leave, the court is going to give you my information. Please call me as soon as you get out of court. Okay?
Yes, sir. Sorry.
I want you to understand that I will protect every person County. And if I have to make your bond $50,000, $2 million, I will do it in a heartbeat, Mr. Lopez. If you don't believe me, ask John. He's been doing a lot of work here and he knows. Do you understand? I'm not asking for much. All I want you to do is stay away from this person. That's all I'm asking you to do, and don't pick up any new cases.
You received videos on that one, you said?
You must remain in contact with him. If he tells me he cannot get a hold of you, or if you pick up a new case, I'm going to revoke this bond and I'm going to set it high. Do you understand?
Yes, sir.
I will have you sign a receipt, Victoria, and then we're going to have you take a seat in the jury box. I'll get your bond conditions. We'll have you sign it, and then after that, you're free to go, sir.
Yes, sir. Thank you.
All right, right this way.
Judge, the last case I have is Mr. Hunter. He's relatively a new case that I'm just hoping to just get a reset.
Judge, for this one, Lopez, was that state bond condition?
No, he's going to be monitored pre-trial.
And then are we doing the regular reset?
How old is this case, I guess? I didn't even see.
92 days old.
Yeah, normal reset.
Was discovery complete?
Alex?
We're still waiting on 911, Your Honor.
All right, Judge, a regular reset for this one brings him out to March 25 through the 27th.
March 25th to the 27th, John.
Gotcha. How about the 27th, Victoria?
Okay.
Thank you, ma'am.
On Hunter,
Yes, Judge.
is Mr. Hunter here? You check in?
It tested negative.
Okay. And that's today?
Yes, Judge.
Great. All right, so we'll give you a normal reset on Hunter. John, you want the same day?
Okay. That's fine.
Done.
27th it is.
Yeah. All right, we'll have him sign here and we'll get him out of here.
Thank you all. With that, may I be excused, Judge? Y'all have a great day.
Three cases. What about Guzman?
Guzman, we're setting to 3/13, the day after the felony. They did a TRAS today, so we're waiting to see what that is. Okay, John D., you're good to go, man. Have fun.
Hey, Judge, just a quick reminder. I gave you a text and an email. If you get a chance to take a look at it, we can talk about it later.
Okay.
Right, Judge?
Yeah, man. Have fun.
Okay. Thank you, Judge. Yep, thanks. Bye.
Bye. Sonia. You're gonna have to speak loud.
I'm trying to speak loud. Can you hear me?
Now I can.
Okay. I have Miss Ray Valorio on docket.
What's the last name?
Ray Valorio.
Was it R?
Yes, Your Honor.
I see it. Okay.
We have a PTI offer on this case. It's a theft by check. She sent me a picture of the money order. I still have not received the money order. She was supposed to be mailing it to me. I still don't have it.
Okay. So what I'll do is this case is 180 days old. I'll set it for bond forfeiture for 1 week. She must be here in person
Okay.
if it's not done.
Okay.
Okay.
All right. Sounds good.
Okay.
That's all I have. Thank you.
Bye.
Bye.
Mr. Elick. So the probation officer is here to testify now.
Yeah, I mean, that's fine.
Do you want to go through it now, or do you want to just issue when it take time served, or do you want to go through?
I mean, I think we should have a hearing.
Okay. Ramona, do you mind setting up, please?
I have somebody else.
No, Judge, I'll be right out.
Thanks.
It'll be just right to Hunter, you're on.
Rick is like, go ahead and sign for your visa.
Yeah.
Judge, I'm Mr. Jefferson from yesterday, and I don't know if it was a miscommunication, but he thought he was supposed to come in today. So he is here.
So we've done PC. I found no PC on the terroristic threat. I
Right.
found probable cause and harassment. I gave him conditions. I reinstated his bond.
Oh, thank you, Judge.
So,
Appreciate that. That's basically all I was
I'll
approaching
just get a
about.
normal reset and then.
Okay, thank you.
Have you had a chance to look at the motion and documents?
On this MAJ? Yes, Your Honor.
Are you ready or no?
So we already sent the PO home. We already sent the PO home. We told her to come back Monday.
Oh, okay. Well, that's
Sorry,
fine.
Judge, I.
No, don't worry about it. That's okay. Yeah.
Ready to go on Monday, for sure. I think really all we'll have is, I mean,
Are there technicals?
one is, I think there's a dispute over the community service hours. There's a.
Let me.
I think that's cleared up.
Okay. So then there was a old positive drug test. I think the big one is obviously is the new law violation, the other injury of the elderly. We'll strike the other one.
Well, I mean, she already pled to it.
Right.
So to me, I think that that's still,
That's true, Your Honor. I mean, I feel good
I
about
think it's
every
still
other
good to
thing.
go. You know, because I mean, it's already been worked out upstairs. So it's, you know,
She pled to it.
yeah. So it's still,
Monday will be super quick.
yeah, absolutely.
Your Honor, if I did have the grandmother appear on Zoom, would you allow her to appear on? I mean, that is the case she pled to.
She pled to the case.
Yeah.
No, I can't, I don't want to relitigate it. And if her purpose for coming is to try to relitigate it, to say that she's not guilty of this offense when she already pled to it, you know, really. That's something that you do in trial.
Right,
That's why you don't,
I understand, Your Honor.
you never plead if you're not guilty.
That's why
right?
I'm asking.
Yeah.
Well,
I don't think that's, I mean, what's your position?
Your Honor, I would have to say that, obviously she's pled to a new offense. She is in violation of it. And she should be adjudicated to the state's position.
I haven't even seen the motion to see what other things. So you say that there's a positive, huh?
There's a positive and older one.
But that's not alleged to this one. I don't believe so. I think there may have been prior ones, but I would argue res judicata, Samantha Salazar.
Do you have what's the newest motion? Do you have a copy of it? Or is it the one from June? Is that the one that you?
It's fees, community service, and the new law violation.
Okay.
No, this is the newest one I have for this case.
So there is a failure to do the community service?
Yeah, just let me know.
But, Your Honor, she did the community service, and I have proof of it. And I think there was a dispute over 10 hours versus 40, but it's 10, and she's done 10.
So allegation number 10 is that she failed to perform the said community hours as directed. They have a deadline to get that done. She did do it. I'm gonna assume that.
She did it late? Yeah, she's still regardless. And then, yeah, I mean, let's go for Monday Monday.
And that's fine. I mean, it's like you said, she pled guilty. And so I don't want to waste everyone's time arguing the case she pled on if there's no chance that.
Like I told you before, there are times there's to be fair, there's times to be easygoing, and then there's times that we have to put the world on notice. You know what I mean? And here we have an assault, we have 2 felony assaults, we have another assault, and then we have another felony assault. I know that those 3 got dismissed, the first ones, but now we have this assault that she pled on, and then she just picked up another. So it's time.
I understand.
Really.
I understand.
I really try to be as fair as I can, but at some point I become an enabler if I just continue, and I can't.
Well, and I just don't want to waste the court's, if we're litigating the one she's already pled guilty to, and And so that, I feel like that would be a waste of time, which I don't want to waste the court's time.
Yeah. But like I said, if she doesn't want to take the time served, the only other option we have is to go through the hearing.
Right.
So
Maybe I can go talk to her again and
up to you.
tell her what's
if,
going
if
on
she
and I'll
wants
be
to do
back.
it today, great. If not, we're gonna have the hearing and then on Monday. Right.
Well, I just want to, we don't want to get into evidence on the case she pled on. Right.
No. I mean, you just,
Right.
yeah, the JNS.
So I mean, maybe there's no reason to have a hearing because that's pretty much what I'm going to do. So
I know.
I'll go talk to her. I'll be back. So.
As far as a trial case, I'm trying to get, okay, Jillian's gonna come by around 10, so we can talk
Yes, Your
about
Honor,
the
and I just
continuance.
realized that there was continuance filed, yeah. We'll-
So understanding, like I told them, you know, I give everyone one bite, right? But not a second one, you know, come, I don't care what day you guys choose after the fact, but at that day, come hell or high, we're going, right? And I don't care if you're missing witness here or there, that everyone has to be on notice that that's the new date and we go. So, okay. Sure, thanks. Hey, do you want those cookies? Not bad. You want those, you want the Chase cookies? Wait. No. Well,
I don't like her. Lopez. Take care of yourself. This is the next court date on March 27th, and then you're good to go. Just make sure you go to that location as well.
First one is.
So then, whatever your information, and so you have her information publicly. I don't think. Do you know the person? Was that?
Yeah, I got trouble.
And I think it was like an agent. So she was trying to pick up a child. And then why?
His full name is Michael Melvin President.
Keisha Jefferson.
What are you watching? What is that?
You have like a.
Easier to get it away.
You can have your altar phone. I'll have mine.
I mean, yeah, of course, but we gotta figure out, are you signing on to the case now?
So same firm,
Yeah, you guys work together, right?
she no longer works there.
What?
We're gonna give them out too.
You should go out on her own or what happened? Okay, well, don't, I guess. Okay, who did you guys work? Okay, so you're taking over.
I don't know if I'm taking over cases, but I'm just taking over their docket for now.
Okay, so
This all happened.
well, it's on today or no?
Yes, Judge. So, and we are working on litigation aspect. We are getting those together.
Yeah, it's gotta be now, because I mean, we're at,
And I'll be working on that.
Yeah, it's at 150 days. So let's do this. Let's set it 2 weeks
Okay.
for you guys to get all the stuff in.
Some that needed to-
And yeah, it's got to be in by the next 2 weeks, the packet.
That's all.
And then I'll sign your motion. Okay?
Thank you.
Hi, Greg. What's up, man?
BVR on Mr. Galindo. He is present today. Younger kid, but dirty UA. That's what I'm being told.
Come up, Mr. Galindo.
It's not a DVR, Judge. I mean, he did a 45, it's been about 50 days, but originally 45-day reset for re-drug test because of the positive test results on December 31st.
Oh, okay, so hold on a second. Hold on. Mr. Galindo, you were charged with evading arrest or detention. You were ordered not to use alcohol or marijuana. We tested you in December. You tested positive. I told you not to use anymore. Did he get tested today?
His mom is here, Your Honor, with him, just so you know.
Okay, where's mom?
Mom's in the corner.
Come up, mom. Do you speak English, ma'am?
Yes.
Thank you so much for coming. So you familiar with what's going on? So he's charged with a serious case. I told him not to smoke or use any alcohol, use marijuana. We tested him in December. He tested positive. I've tested him now. We are roughly almost 3 months later, and he tested positive again. Same thing. Sorry, bud. Goes with you. I told you not to use. That's it.
Talk to you.
I got to show you that we're serious. I'm sorry, man. Yeah, 5,001.
Can I ask what the bond is, Your Honor?
Yeah, 5,001.
5,001?
No, you're not to use. I hope now we get your attention, but I don't know what else we can do. Okay, sorry. Goes with you. I mean, we can wait.
Well, I was going to do a mitigation packet and submit it to try to get him a pretrial intervention.
But still do what you need to do.
Okay, so,
Still in there.
okay, let me talk to Mom. If he makes bond, he'll pop up tomorrow or Friday.
We're not out for blood. If a couple days he's still there, we can talk about it. But I have to show him that I'm serious, you
Okay.
know, and he's just not getting it. It's unacceptable. So
Okay, I'm here tomorrow and
I
Friday.
said, we're not out for blood. We're not out to hurt, harm, but he has to know that we're serious. So if he's still in there within the next, today's what? Today's Wednesday. You know, give it a couple days, still there, we can talk about releasing. And I'm going to continue it. So at this point, once he does get out again, I'm going to test him again within the next month and a half. If it's again, same thing, but I'm not going to continue to play the game, and I'm going to let him know, you know, when we do release him, however, or whether you bond him out or whether he gets released, I'm going to let him know.
Okay.
I'm not going to play this game with you again. Next time, it just, all it is, keep going up and up and up and up. What, is he in high school? What is he doing now?
Well, he's in high school. He's in high school, and they actually started to harass him. The next one when they went to school.
Let's not talk about the case. I only want to know, so
I think she's talking about the school, not the case here.
Yeah. So he's
why don't we set it for Friday? Okay,
Okay, I'm here.
and then we can talk about, you know, releasing Friday.
But Mom can bond him out today if she wants.
Of course, I mean, that's up to you guys, right? But I'm letting you know, I will by Friday, and I'm going to admonish him, look, I'm not going to continue to play this game with you, you know, and then
Okay, so I'm gonna put him on docket just on Friday, no matter what.
whatever you want.
Okay. Cool.
And then work on the mitigation packet at the same time.
I mean, he's got it from my Mom can give me the proof of.
I mean, you can get, I mean, I don't know what all you need for the mitigation packet,
Yeah.
regardless, but he's a
He's got to write a letter, which. Yeah. So,
probably now's the best time while he's in. He's got a lot of time to think, right?
getting a pen and paper, but anyway, we'll discuss Friday. I'm gonna talk to Mom about bonding.
And then Do we need to put a curfew on him?
He's not a curfew now.
He's got the curfew? Okay, all right. I didn't know whether we did or not. Okay. So we're gonna put him off for Friday.
Friday?
Yeah. And then if he bonds out, he bonds out, but otherwise, Friday, I'll let him out and then I'm gonna move him. But don't tell him,
No, definitely.
because the worst part of being in there is not knowing when you get out.
Yeah.
It's awful. It smells.
They're in trouble, so
It's awful. I don't know if you've been to jail, but there's no clocks, there's no windows. It smells like holy hell. It's awful. So hopefully it's enough to get his attention. All right.
Thank you.
Thank you.
Friday. Yeah.
Judge is approaching again on Mr. Jefferson. The state is asking for his next appearance to be required so they can serve him with a civil protective order out of the 280th. I would ask for
That
his
works.
appearance to
How's
be.
that gonna work?
Yeah, so Your Honor, in this case, the complainant through our office is applying for a protective order. So we're just asking for his appearance to be required just so we can serve him the protective order, and then the civil division will take it from there.
I would object just for inconveniencing him, Judge, and don't they usually just have a deputy come out to your house and serve you?
I don't know. I mean, I've never done the 280th domestic violence to where I don't know. I mean,
I've encountered them a few times, but I've never dealt with the process of my clients being served them. They just get served.
so you get, so you apply, you've got the hearing, you have to serve him so that way he can go to the hearing in the event that he wants to
And that's
contest.
all we want to do is get the
Right.
process started so we can protect our complainant in the case. And we would have had him served today, Judge. I just don't believe that things have been.
Want me to do a protective order now?
No, this is the long-term civil protective order, not just the MOAB, Your Honor.
And they already have a no contact.
We do, I believe, have a MOAB on file.
You want me to
in the
put a
case.
MOAB in now?
Sorry?
You want me to put, did I already do a MOAB?
Yeah, I thought you did.
I believe we do have a MOAB in this, well,
No.
in the prior case we do, in the new case,
No, that wasn't signed.
Let me,
We just-
in one for
yeah,
now,
yes.
because I know that he has the harassment, he has the other terroristic threat. I didn't realize that you guys had filed it.
Judge, he doesn't live with the complainant. They share no children together. He has no problem staying away from her.
Mr. Jefferson, come up. Mr. Jefferson, on your harassment case, I'm entering in what's called a magistrate's order for emergency protection that identifies Ms. Green as a protected individual. As of this day forth, she's now protected, meaning that you cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you violate this court order in any way, the state can and probably will file a violation of a protective order against you. It's one of the worst cases you can pick up. Do you understand?
Yes, sir.
So I'm going to have you sign this now. The state's asking me to have you come back so you can be served, but I don't do that in any case. And I don't want to show preferential treatment for you guys, you know, like I would show preferential treatment to them, because unless I know that the person is a flight risk or homeless to where we know we're not going to get a hold of them, I normally waive on everybody. And I can't, it wouldn't be fair for me to show preferential treatment to have him
Your
come
Honor, we
back,
just
you know?
had to ask.
So will acquiesce in granting a protective order now, but so what I'm going to do is I'm waiving your appearance so that you don't have to come back and waste your time in court here. But you must stay in touch with Mr. Sims. And if he tells me he can't get a hold of you, then I'm going to issue a warrant for your arrest. No more PR bonds. Do you understand?
Yes, sir.
So if you start to become a problem out there in the free world, I will take the free world away from you. No more PR bonds. You pick up a new case, no more PR bonds. You start harassing, no more PR bonds. I'm not asking for much. All I want you to do is stay away. There are a gajillion and one fish out there in the sea. It's not worth throwing your life away. You understand what I mean? Life is way too short to live in a 6x9 box. Jail sucks. It's not fun. All right. I'll have you sign the protective order and then we'll get you guys out of here.
Thank you, Judge.
Thanks.
Do you have the law conditions too, or we just? He's 25, right? Many will think the protecting order is sufficient. Just sign it first.
Hey. Good job. Hey, you want these Chase cookies? You want some cookies? No? You want your milk? Oh, yeah, I always wanted her. Are you opposed or unopposed?
Let me pull it up, because I didn't get served with it.
Well, that's why I'm calling you now, because they just filed it now. And do you want me to print it out for you?
You have a felony thing. So, let me see, look at that right.
Tell me if you need the cause number. Yeah, he's got an evading upstairs. That's right, Jillian.
There is queue, he should be on file, it's just the no contact with the plan. Yeah.
Just like you've been in law school 9 years. Been around 50 minutes courtroom. Like 3 or 4 of your chiefs.
I have a business background, but yeah.
Or cheese, right?
Yeah, we got all chiefs.
Or five.
I think 5 of us.
But no, it's this, yeah.
One week.
Yeah.
I've earned my stripes till the yeah, this should be 5 years.
Hey. Miss Turner has a trial case on for next week. Remember, Miss Sands just subbed out Miss Turner out of the case. So there's a trial case set for next week. Right, that's what we should like get ahead of it so that we don't get the. You want a cause number? 246-7835. And it looks like Miss Sands is on his felony too.
So. I can try. A lot of times they
I'll listen to this. How am I gonna get on?
Because she basically, okay, so, but I understand, it's a CPS. Well, no, also says no. So.
Yes. Yeah, that's right.
I'm sorry, I was covering for. That's why you tried to do that. Yeah, I talked to him.
Whatever.
But I did not final word, so.
Okay. I think it had, I think that's, she's so like that.
So I don't think we need to do all this.
Yeah, I was about to say, I don't think.
It's
we
just
should-
an MAJ,
Right.
so we just do the child court certification.
MAJ?
It's an
Oh,
MAJ.
no, this is the one.
Right, and I just.
We need a stipulation of evidence.
It's okay, not a big deal. So we just need the trial court and then there's also the stipulation and then that's it. Yeah, I think, I don't know, maybe they filed it incorrectly.
Yeah, I mean, I think we need to plead true on something.
Correct.
Yes,
Right. So I guess, do you want to do the technical?
I mean.
Because I mean, theoretically, I guess it's done, but it's not done on time, which is still a violation. Or do you want to go on the new law?
I mean, to me, if she's already pleaded guilty on the injury to the elderly.
Just do the new law then.
What's it gonna hurt to plead true on this?
Okay, just we'll do that. Yeah, I got it. Jillian, hey, ready?
Opposed on the continuance for Myers.
Propose.
Unopposed, sorry. I'm unopposed.
Okay, so I let them know you only get one. You don't get any more. I don't care who's missing the next time. We're going forward without the witness if they don't come.
Yeah.
Judge, we did put in our continuance that we're requesting a new date of March 11th, just because I do know that that witness is available on March
Jillian, are you
12th.
okay with that? That would be-
Judge, before they start, they set it for March 11th, 12th. That's the week of spring break. And we're gonna be short-staffed. Is it possible they can go to the next week?
I honestly don't think
Look,
so with this
it's not a
lab.
big
And
deal.
in the absence of March 11th, I would ask just to set it as far out as you're comfortable doing, just because this lab does need
Why don't we
the
do
most
this?
amount of notice possible.
Look, I'll grant you continue. Why don't we regroup tomorrow? Can you
Okay, I'll make
talk to
a
her or him today and say, hey, are you okay with, or what's good for you? Is the 18th okay?
Yeah, all of March, except the first week is fine with me.
Okay, so there you go. You got your pick of any, except for the March 11th because it's spring break, I think
18th or the 24th?
18th or the 24th.
Do you mind if I regroup tomorrow to
Yeah.
confirm? Thank you.
I'll be here.
Then we'll set it for that day and then I'll just grant it now and then, yeah.
Sounds
Okay.
good.
Thank you.
Do you want to go? Do you want to go through some stuff or no? Oh, get when you're done.
Very few that I need to color.
Yes. I looked at all the people last name Aaron. Yes. It's a trespass.
Okay.
And which, I mean, if I thought, if there was. Right. I actually got it pulled up. Just give me a second. I never got it. That's just- I'm sure they're on the- Oh, there you go. Do you want to share it?
Sure.
Yes, I am.
Thank you so much. Another one, November.
I thought that was decision making. Yeah, I. Hey, man, you got a minute? And then.
Whoa, I mean, wow.
How are you?
Hey, what? I mean, how's it going?
Good.
You look great.
Thank you.
Like you're running like crazy. I see.
When I'm not running, I'm walking. Still.
That's great. No. It shows. You look great.
Thank you.
How are things? Where you been? Are you working more
I'm
still?
on this floor now.
Wonderful.
Through, I think, June.
I mean, it's been 4 or 5 years since we've
Yeah.
even been on this floor. Have you been on?
I've been on, I haven't been to 8 in a long time, but, I've been on 11 and I've been on 11.
Okay,
Nice.
well, good. How are things? Everything okay? Mateo's college now?
He's a senior in high school,
Oh, senior.
so soon.
Are you ready?
I think so,
He's going to A&M for sure, right? There's
More than
no,
likely. I mean, this
Yeah.
is 99%, yeah.
does he know what he wants to do?
He wants to do sports management.
Okay.
So, like work in front office of an organization. I told him, I said, after your undergrad, you should go get your JD MBA.
Yeah, that'll, be the next Scott Boras,
Yeah.
That'd be amazing. Holy moly, I mean, that's what these guys, he's got to be a lawyer, right? Because I think that's where it's, I mean, if you would be like the next Scott, you know who that is, right? He's like the
Right.
management to all the
Oh, yeah,
stars
he
and
was
yeah.
The one that milked the Red Sox for all that money, Alex Bregman.
Yeah.
Did you
Wait,
see
is he
the terms?
is he managing Bregman?
Uh-huh.
I didn't know that.
That was one of the big, did you see the contract? And so it's 3 years, 120. And you're like, that's $40 million.
But how much guaranteed though?
Almost all of it.
No.
Yeah, but here's the thing, is that when they gave the breakdown of the contract, it's a $5 million bonus, signing bonus. And so salary for this year is gonna be 20 million will be deferred. Next year, 20 million deferred. And then the third year is 20 million deferred. So he gets a total of 60 million deferred onto to start paying him in 2035.
What?
Yeah, so basically we're not even playing anymore, we're collecting money.
That's like, who's that other player that's still getting paid even though Barry Bonds, right? He still gets every year or however.
First, he gets $1 million.
Yeah, isn't that crazy?
This is the 90s, yeah.
It's just nuts. And it's been 20 years. He's still getting $1 million every year. I mean, what a.
That's like what Tony's contract. Tony's like,
wow,
50 million a year.
That's
but
what I want.
Most of that is deferred.
Yeah. So you can be, are you with us now or no?
Sorry?
Are you with us now? Are you working with us?
I was assigned in here today, so I.
Great.
Victoria.
I don't think we had, but maybe one.
Yeah, she
maybe
only had
two.
one, and she got it.
Yeah.
Told us otherwise, it would be down on the floor, just.
Okay, well, thanks. And then I mean, I have your cell phone. We have Zoom. You can always appear via Zoom if you can't make it. So really, I mean, however you want to do it, we're as easygoing as can be, right? So, yeah. Well, that's the way, I mean, I trust you to do what you're going to do. I know you. And
yeah.
Just whatever you want to do, you do. All right, Juan, great to see you, man.
It's like the extra, like the other, whenever you're typing as a regular.
Yeah, this is the stipulation.
Is this the you have to walk forward and if you want to be true to whatever they want to be true to, you just have to. And like how many, this is about like, all representing specific. Yeah.
Well, that's good. Okay.
Usually it'll just be like the first person, usually they would do what they knew off. Attempt to turn in, if he's in plea, should go to this middle one.
Okay.
But I'll leave that to you guys.
Sure.
We just send everything.
We just, I'm previewing it right now. Barrington?
Go around.
Oh,
What's that? Just.
yeah.
Judge, did the motion for conditions go to Jefferson in your?
I signed it.
Thank you. Keyshawn Jefferson?
Barrington? Okay, it's on the phone, so, okay.
Keyshawn Jefferson. You're gonna go ahead and sign for your bond conditions right here. Go ahead and sign and I'll print it up. Here's a copy of the protective order that was signed earlier, but if you have more questions about it, ask the attorney. But that's your protective order will be the next 16.
Nathan.
Hi, Judge.
Hey.
Hey, I gotta apologize about Saturday. So I had,
My fault.
well, I had texted you a day and then you asked me if it's Saturday and it's like, it was a Saturday, but not that Saturday.
I should have clarified it. It's my fault.
It's all right. I owe you a nice lunch.
Well, I can't take that anyways.
Well, I'll take you out for a nice lunch as an honorarium from the kids. I don't know. Oddly enough, Humble has a good Indian restaurant if you like Indian.
Who doesn't?
Oh, lots of people.
I love it. But thanks for the send.
It's fine. I have two, Judge. First case is Franklin. Thank you.
It's not, oh,
So, on bond for terroristic threat, picked up a criminal mischief. The criminal mischief,
now?
he is here. And the criminal mischief is that he supposedly broke a window inside of an apartment.
We have to do PC, I don't know.
Yes, Judge.
LaDon Franklin, come up.
Go around for. I'm gonna add the word supposedly and allegedly, like salt and pepper in this case, because nobody saw it happen.
Well, we still have, yeah, give me a second.
Yes, sir, no, sir, okay?
Hold on.
Does he, hold on. That's gonna be the creepy grandpa and offer candy, but all I've got is peppermints. So arms by your side, stay calm, don't talk, okay? All right.
Council for reset? Oh.
Here, love. All right.
Okay. Appreciate it. Thank you.
Mr. LaDon, you are on bond for a terroristic threat. You've now picked up a criminal mischief. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On February 11th, 2025, the officer responded to a physical disturbance at a residence in Harris County, Texas. Dispatch advised that the caller was reporting he had a knife and was going to stab someone because they were bothering him about a broken window. The officer made contact with the defendant and the complainant, and the defendant stated he called the officer. The defendant was found to be in possession of a green stuffed animal which had a fixed blade kitchen knife concealed inside. The defendant stated the complainant came to his house with her roommate, accusing him of breaking a window at her apartment.
Well, hold, you're going really fast.
Yes, sir.
The defendant,
Called the officer.
okay,
And he said that the complainant had come to his house with her roommate, accusing him of breaking a window at her apartment. The defendant stated he was walking back to his apartment and that the complainant came out the back door to her apartment, but then he changed his story saying that she came out the front door to her apartment to confront him. The complainant stated that the defendant stated that the complainant came with a gun, though he did not see the gun. The complainant stated that she was laying in bed, heard a glass window in the back door break, jumped up, ran to the back door, and saw the defendant walking away from the door, holding a green stuffed animal with a knife. Apartment management stated the cost to repair the window was $200.
There's a lot of randomness in it, Judge.
the only thing, my concern is who broke the window? Did he break the window?
And Your Honor, so according to the DMs, what the complainant said is that she saw him walking away. She heard the broken window. She came downstairs and saw him walking away. And then that's what we have in the DMs. And then I spoke with her yesterday as well. She repeated the same thing, that he was the only one there when the window was broken. And that's what she said. She saw him outside the window door when it was broken.
He's walking away. He actually calls the police because he's being harassed by this woman because she's saying that he broke a window. And I don't think there's any list of physical evidence like glass on him or anything, or in the whatever stuffed animal.
At what point did the cops come and did they arrest him on the spot? What, do we have any other physical evidence? Do they?
We have The two further was complainant said that he was approximately 20 feet away from the back door when she saw him and that the officer found the window to be shattered. And then the complainant showed the back door to her apartment.
I mean, how do we know he did it?
No one's saying that he did.
I mean, no one saw, you know, it's.
To be honest, just what we have is that the window was broken and then she saw him outside at the time when she came downstairs to check on it. That's what we have.
I get it. I
Yes,
get
Judge.
it. I don't think it's enough. However, the fact is, we're still having issues with the same complaining witness. I now have to take more drastic action to ensure nothing happens in the future. So now what I'm going to do is I'm putting an ankle monitor on it and I'm barring him from going within 500 feet of where she lives or where she works.
Yes, Judge. Ankle monitor, just want to make sure it's ELM and not scram.
Correct.
Okay. Asset fees be waived. Okay. I'll add.
How far do they
Judge-
live from each other, Alex? You know?
Do you have the same complex?
It was described as across the street. But when I spoke to the complainant, she said that they do not live across the street, that he was staying at a friend's house. But he told officers that she lives across the street.
So what I'm doing, Mr. Franklin, is I'm going to put a monitor on your ankle and there is a radius of where you cannot go where this person lives or works. And I mean, we may have issues with bond conditions as it is, because if I ordered him not to have weapons on the terroristic threat and they show me that, or they prove to me that you have weapons, I'm going to put your butt in jail. So maybe we should have a formal bond hearing to see if in fact you can prove that he has a weapon.
Yeah, Judge.
So I have some hesitancy about everything, Judge, mostly because my client's orange sheet is quite extensive. So the jail has diagnosed multiple mental illnesses. I'm trying to track down his competency because I was appointed, I think, December. So there's been prior competency motions. I'm trying to get the reports from them, which is difficult because I forget what agency does the mental health evaluations. They're saying that they don't exist. So I'm trying to find his mental health records, Judge. It sounds to me like it's bipolar schizophrenia or schizoaffective. And so I think that my client is likely going to have severe mental health issues, which have been causing issues. And I think that's going to be the heart of all this. And so I'm trying to push for treatment. The case is just brand new is the problem.
You were ordered not to be in possession of any weapons. And they're telling me now that you have a new case and that you have an alleged knife as well. I want to set this for a formal hearing on Monday. And if they show me that you have a weapon in violation of your bond conditions, I'm going to bring it. Do you understand? You are not to be in possession of any weapons whatsoever. Get a hold of your witnesses, get a hold of the cop. Let's have a formal hearing on Monday to show me whether he's in possession of a weapon or not.
Yes, Judge.
Yes, Judge.
In the meantime, like I said, if I find that you become a danger to my community, it's really not going to go well for you. Do you understand, Mr. Franklin? There is no excuse. You will get this ankle monitor today, and you're not to go within 500 feet of where this complaining witness lives or works.
If I can politely ask, Judge, that we reset for more than Monday, only because this case is new enough that there's literally no offense report. So I don't know officers' names or.
Case.
So the new case, the criminal mischief, which will be the allegation for the motion.
Find no probable cause in the criminal mischief.
Well, but the problem is, Your Honor, is that it's on the criminal mischief that we have the officer that saw the alleged knife. So we'd have to get in contact. We don't have the OR. We have the name. I could reach out, but we don't have the OR to give defense. So that way they can review it. And
so the allegation is, and it's, we don't have an OR, so we're reading DIMS. So the allegation sounds like the officer saw a knife, or maybe the CW saw a knife. It's unclear.
To me, it sounded like both saw a knife. And so
Well,
that's why.
I don't know
So,
if
I
anybody
mean,
did.
I guess I'll give you a full week. You know, that should be sufficient for you to get an OR,
Yes,
get in
Judge.
contact with both witnesses.
just to clarify for both parties here, the officer is the one that said when he contacted him, he's found the defendant in possession of the knife.
Okay, let's have a hearing.
Yes, Judge.
Get this guy over here. If you need to subpoena him, do it so that today's Wednesday, we'll have a hearing next Wednesday.
Thank you, Judge.
All right.
You have to see it.
See you in a week.
Let's see, I'm gonna talk in a moment.
We're finding no PC on the criminal mischief.
Yeah.
And I had a question. I'm sorry to interrupt, but earlier when we had Mr. Sims here, Mr. Judge.
I had a murder case in Baytown by the time it went to trial.
No.
On
Well, it was a retrial.
The older one.
3 or 4 of the officers.
The terrorist affair?
I think the terrorist affair was when we know PC. So we were gonna.
Hold on a second.
Because you know PC, the
Third
nerd
one,
ones.
we had pulled over a lady.
And I had him sign them all up on.
Okay, yeah, it's on the harassment now.
Yes.
On the mo up on the harassment.
I'll dismiss the ticket. I'm Mr. Wiggins, which is Anna Edie's case. I signed on as co-counsel. She asked me to come in and reset.
Okay.
He's in custody. He's got, I don't remember how many cases, but most of them are felonies. Yeah.
Looks like they set it to April 2nd. Is there, I mean, those things are gonna last forever because there's so many cases.
So
There's 1, 2, 3, 4, 5 felony.
due to the severity of the cases and the extent of the cases, I would assume that they're going to move slow. But I'm not felony lawyer up there, so
And let's put it there for the day after.
that's fine by me.
And I'm willing to carry it some time, but not 2 years.
Yeah.
Yeah. Okay.
Thank you.
Hi. Of course. Good morning, Ms. Ferris. Great to see you, man.
You know, it's interesting. Every time I come in, your beard is either growing out or mine's
Right.
disappearing. So, but
Matching.
good to see you, Judge.
Twinkies.
Approaching on the Matthew Gomez case, and Judge, he's here and it's on your bond docket, but there's a BVR issue. I've talked with the state about it. Talk to them about what I think are some interesting issues, kind of by way of background in our case. And the state had previously offered, though we had not yet gotten the contract, to do a 90-day mental health PTI, which we felt was appropriate. They're going to review with the felony court to determine whether they still believe that may be appropriate, but they can't do that at the moment. They're going to have to get some feedback and find out a little bit more information about the new felony charge. I read the cases and think there's issues with both of the cases. But there is the pending BVR based on having picked up the new felony charge and need to.
Is he here?
Yes, he's here.
Come up,
Can I call him up?
please.
And it's not really our issue to delve into, but I think there's issues with the way the police officers maybe made the stop in the new case. And
If he's picked up a felony offense, I'm very upset.
we understand. And
Let me express my disappointment with you, Mr. Gomez. You picked up a felony assault of a peace officer while you're on bond for this case. What happened, please?
So in the felony, the officer dispatched to a suspicious person call at a closed gas station. They observed the defendant walking around the vacant lot holding 2 glass bottles of Corona beer, indicating possible intoxication. They attempted to stop and identify the defendant, but he ignored commands and walked away towards the main road. And despite multiple warnings, he refused to comply, and he threw a glass bottle at an officer before fleeing on foot. Officers pursued the defendant for half a mile before detaining him, and while being transferred between patrol units, the defendant had already moved his hand restraints to the front of his body, and the officer attempted to reposition the restraints behind him. That's when the defendant pulled away and struck the officer's left thumb with his elbow, causing pain, redness, and tenderness. And then the defendant attempted to flee again, but was taken to the ground.
And I think there's issues with walking up and saying, we see someone and no more. Well,
It's
I know it's
not our case to litigate.
Well, I know.
All I know is that you've now picked up a felony case. Where'd you going? I gotta take him.
Judge, well, if we're going to be revoking him on that, then I do think it is our issue to delve into. And I think there's issues with the way he stopped. And, but if that's going to be the basis to revoke him, then this court doesn't. But the entirety of the information that the officers receive is based on what I would contend is an illegal stop. You can't just walk up and say, without more, there's no
Go
reason.
up to a guy and say, hey, let's talk.
No, that's not what they said. They said, walked up and said, show me your ID. And that's an illegal detention. That is a detention and it's one that's unlawful under the circumstances.
I don't know.
Well, I'd like to set it for a hearing if we're going to do that.
Sure.
And he posted bond, 10,000 in the felony case. We think that's sufficient to ensure that he appears for a hearing, a formal hearing on it without needing to take him into custody. I've talked with his mother his mother has had good contact with me throughout this process, and she'll ensure that he's here. I think if we set it for early next week, then we can delve more into the felony case and figure out if the mental health, I think the state can get an answer about whether mental health treatment is what's appropriate. We think it's appropriate, and even if you delve into the background of our case, the allegation is that he called the police himself and said, hey, I've got traffic tickets, come arrest me, come to my home and arrest me. An allegation, well, and that he also said, and when you get here, I'd like to be in a fight. And when the cops arrive, they oblige him, they put their tasers away and fight him. And that's consensual conduct. And whether we like it or not, humans have the ability to consent in physical fights if they like in Texas. And it may not be something that we would do or agree with, but legally people are entitled to do that. And so he's not resisting arrest even in our case. So we think there's issues in our case, but we thought on the defense side that it may be more appropriate to go the Harris Center route and see if mental health PTI.
I appreciate your argument. I appreciate your tenacity, but I have to be fair to every single person that comes through here. We have certain standards and procedures that we follow.
Sure.
When anyone picks up a felony case, especially a violent felony case, we revoke the bond and we put them in custody. We cannot continue to act in this manner. We are a civilized society and actions have consequences. I'm happy to give you a hearing, but no, I'm taking you into custody. You picked up a felony assault of a peace officer.
Judge, and my position respectfully is if he's entitled to, Judge, before he be taken away, we finish this portion of the hearing. I think he's entitled to be present at that. But we think it also a part of due process that before a revocation occur, that you're entitled to both notice and an opportunity to be heard. And if they're going to be seeking to revoke his bond, then under our rules of evidence, it's very clear in Rules of Evidence 101 that a revocation, the rules of evidence apply. And everything that's gone on this morning is a proffer by the state, and I respect the proffer, but that doesn't meet the standard for the rules of evidence. And that's why
the judge found that there was enough probable cause for a felony office to be filed against him.
Sure.
I don't want to relitigate a felony case here in misdemeanor court.
And I think that's fine. Well, but I think we're entitled to if we're going to be, and that's what the hearing would be for. But that
one of the conditions of his bond is not to pick up any new cases. He's picked up a new case.
And as an evidentiary matter, there's been no presentation that he violated the conditions of bond. I know that you can look in your system and even take judicial notice of that court's finding, but that finding and pleadings that charging him with a new crime, those are not self-proving. And if they're not self-proving, then there's no actual evidence that's been presented. And we'd be entitled to ask questions to prove up, for instance, that they illegally stopped him. There's no basis for that detention. And so respectfully, I'd like to set
not going to relitigate the felony case. I'm not going to. You know, I respect your position, but I'm not going to.
Well,
he violated a condition of his bond.
Says who?
Says a felony court magistrate that put on the case again. That
he's entitled to be heard on that.
And he did in felony court.
I don't believe that that's.
He goes in front of a magistrate. He has a defense lawyer in the magistrate, you know, when they do the magistration. So he does.
Well, I think he's entitled to be heard here. If you're going to revoke his bond, I think he's entitled to be heard here. And that hasn't happened. And it certainly hasn't happened in accordance with the rules of evidence.
I would just say that, just reiterate that a district court has found probable cause in this case. To say there's no evidence that he violated a condition of bond is flat out wrong, because a district court judge has found probable cause on this new bond. She is picked up.
And that's not self-proving. Otherwise, in trial, they could just come in and bring in that piece of paper that finds probable cause and submit that as evidence, and they can't. That's not evidence. Those are not self-proving findings.
We're not in a trial here,
well,
right?
Well,
you know,
no, I know
this is just, we're having a bond hearing.
Sure.
He's violated the condition of his bond. I understand that you don't like it. I appreciate your tenacity, but okay, and reasonable minds can differ, but he's picked up a felony case and there's a certain process that we follow.
Well, and so we'd like a hearing on that.
Yes, I will give you a hearing. Yes, but I'm taking him into custody because he's revoked and he's a danger to the community. I find by clear and convincing evidence, he refuses to comply with his conditions of bond. Goes with you. I'm sorry, Brian, but I mean, really, every case, when they come in here and they pick up a new case,
I
It's
respect.
just especially a felony assault of a peace officer,
Understand.
you know?
I just believe that it puts the cart before the horse to make the decision to revoke based on pleadings when case law is abundantly clear that pleadings themselves are not self-proving and that the rules of evidence apply in a revocation proceeding. It's in Rule of Evidence 101, I believe. And nothing that has taken place this morning has been in accordance with the rules of evidence. I understand the court's, I understand that as a historical matter, folks come in and proffer information and I proffer information and we don't do it from an evidentiary standpoint. And that may be what the hearing would serve to accomplish. And so if the court's position is after a hearing, you'll revisit the issue about whether to reach a final decision to revoke his bond or not, then we can respect that.
Sure, I'm happy to do it.
Okay. And in the meantime, I guess I do need to request that the bond, a new bond be set in an amount that he can.
Of course, yes.
In the event that his family elects to get him out before the hearing. And in light of our discussion.
What I normally do in these types of cases, I always set it at 5,001. Okay? If you reach out to the family and they have a problem, then we can talk about it.
Well, and I'll let the court know the bond was set at 40,000 in the felony case and reduced to 10,000 because the family doesn't have a bunch of resources. His mother is worked to get him out on bond on that case and is going to have to do the same here, but it's really money that's coming out of the mother's pocket. And so which my whole position was get him access to resources. Now we're diminishing resources and I respect that. I understand, but it's the mother's resources, not his. And so, and the mother, and we knew that this issue was coming up this morning and he showed up. And that's part of the goal is to ensure that he appears, and he did, and to ensure the safety of the community. And I think that part of the finding will address the hearing. But I've been.
What do you want as far as the bond?
Well, I'd like it to be at 2,500. And
State?
Stay would already for 5,000.
Okay, when I have this kind of issue, I always split the puppy. So I'll set it at 3,750. Okay? If there's still an issue, come back and we can talk.
Yes.
But there has to be a sufficient so that he understands, right?
Well, and part of the discussion was, do you really get to that point of understanding if, for instance, the allegation, even underlying our case, is you call the police and say, come arrest me, I've got warrants, supposedly telling on yourself. But when you get here, I'd like to engage in a fight. And then they come and oblige him. I don't know that that's even resisting arrest. And so,
well, it seems like to me that he's just trying to take off the whole time. He's trying to physically, or he's evading the entire time.
No, I think it's case two.
He throws something at
that's
the
the
officers.
felony charge. I'm talking about our underlying.
Oh, our case. Okay, I'm sorry.
And I think probable cause had been heard before I even got appointed on that case. But I think even revisiting those facts, I've talked with the state at length over the course of settings. And my position is, if you invite someone to a fight and they say, sure, we'll engage in a fight.
If you want to set this for a formal probable cause hearing on the resisting, I'm happy to do
Well,
it.
we may address it the same time we do the bond hearing on the same case, if
Happy to
that's
do it.
appropriate.
Absolutely. I'm always willing to revisit probable cause, always,
I know.
at any time, whenever. So just if you want to set it for 3 days, we can have a formal probable cause hearing on the resisting. I'm happy to do it.
It may give the state a chance to find out what felony's position would overall
Right,
be.
and that's state's, but I don't want to litigate a felony. I wouldn't think that's proper. I understand they're entitled to a hearing, but a district court judge is not probable cause on this. I'm not going to be in a position to litigate the felony now.
Right. Let's set it for 3 days, set it for the hearing. Let's do probable cause as well on the resisting, and then we'll come back and just be ready. And then if you can show me that there's no probable cause, I'll find no probable cause, then we're done.
Sure.
That's it.
And I appreciate it as always, Jim.
Absolutely.
Thank you. Thank you, guys.
Brian, you had one more that you have for Laura. Laura.
Judge, there's this moment for Jefferson.
Okay. Are you ready, Ms. Shealy? All right.
Judge, also just a reminder about court 10 today.
I have to go to court 10?
Yes, Judge.
Dang, man. You know? I mean, what do you want me to do? Why are you giving me this?
Oh, that's, the front page, it's the stipulation that it's like, with the 140 for.
Oh, I see. Okay, got it. All right, all right. So Ms. Salazar, you were placed on probation. I'm sorry, you were placed on a deferred, right? It's a deferred, right?
That's right.
You were placed on deferred for assault of a family member. You need to understand something very, very serious is happening now, where you are pleading true to the fact that you have since violated this probation by picking up the felony injury to an elderly. You need to understand that this will now go on your record. It will now reflect as a conviction on your record, and there's an affirmative finding of family violence. What that means is that if you ever pick up another assault of a family member, you will be looking at a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. And it doesn't have to be a drag down fight brawl where you're punching. No, you just grab someone's arm and squeeze enough to where it hurts. You were looking at up to 10 years in prison. There's one irrefutable fact here is that it's 1, 2, 3, 4, 5 different assaults. 90% of the people that are in jail because they have no self-control. They get upset, they wig out without think before you act. You have children, right?
Yes, too.
Who suffers the most while you're in there?
My children.
That's what you need to think about. If I get upset, who's going to suffer? So is it true or untrue that you violated your probation, man?
True.
All right, I'm going to find that it's true. I'm going to reform the judgment to reflect as a conviction now. I will sentence you to 140 days in jail. I will give you credit for the 49 days that you've done. There is an affirmative finding of family violence. All right, man, we wish you the best of luck.
Thank you.
Self-control.
Yes, ma'am.
Good luck, man. Thanks, Mr. Mendes. All right, Mr. Yin.
Matter. My client was on the docket for today. His name is Yaxcal, Yaxcal.
29.
Okay.
Your Honor, there was some miscommunication. I wasn't able to contact him. He had to change his phone number. I told him he had court today. He wasn't able to make it, but I told him if I can go to court and see if Your Honor would be kind enough.
205 days old. Did you guys submit the mitigation packet?
I don't think he's gonna do that route, Your Honor. He's gonna be plea, Your Honor. But we'll be able to roll it for tomorrow, and I'll make sure that my client.
Okay, I mean, if you want tomorrow, that's fine.
Sir.
SFBF tomorrow.
Thank you
Okay,
very much, Your Honor. Have a great day. Thank you. Thank you.
Okay, hi.
Hi, good morning, Judge. My client is Michael Jones and he's in custody and he's asked me to argue probable cause for him and so I
Sure,
shall.
of course. You ready?
Yes, Judge, does he need to be brought out or do you, I don't know your process.
Mr. Jones, please. Yeah. It's only fair, right? Because it's his case, so.
You didn't hear me.
It's only fair because it's his case, so we might as well bring it up.
No. He asked me to do this and so I told him I would.
Yeah, this is Michael Jones.
Yes, Michael Jones.
Okay,
That's my client.
he must be unhappy, huh?
Asked him to breathe.
Or hungry.
Asked him to breathe.
You said Jones, right? Michael
Yes,
Jones?
Judge. Michael Jones, 254-6980.
Talk to me while we're waiting.
Yes.
Yes, Your Honor. It's an off-docket matter.
The cause number?
Yes.
Okay, the cause number is going to be 25389 at 37. It's Mr. Tygoon.
Right, Tayun?
Yes.
Okay.
He's in immigration custody. I've spoken to the state and I have an offer of, he has 2 pending DWIs. We have an offer of one, pleading guilty or doing 18 months probation on one and the dismissal of the other. We just need to issue.
Probation, I mean, he's in custody now. What's gonna happen?
So we were hoping maybe we can have him bench warranted and then we could bond him out of immigration custody. We just want to.
Do you know, have you gotten an immigration bond already or no?
We haven't done it yet, Judge. We would like the judge to know that we've already have an offer for the criminal court and have it completed so that we can tell the judge and show them.
I'm gonna tell you, I don't know if would be down. I mean, the first thing that I would want to do is have a TRAS done to see what would be the appropriate way, because he's got 2 open DWIs. You know, they may say he needs residential treatment. They may say he needs something else. I don't know. So on a case like this, if you want probation, the first thing I would do is I would do a TRAS. So if you want a bench warrant, we can. I mean, there's a warrant already now, Vic. Would it be duplicitous to do a bench warrant or no?
Right, because the warrant tells them we want them.
Because the warrant already tells them we want him, and they're not sending him to us. So what's the status for the hearing there? Do you have an immigration
So we
hearing?
don't have an immigration hearing set yet. I don't think that they're gonna let him do a bond hearing just because of his double pending DWIs. That's why we were hoping maybe we can get him bench warranted.
You want to do the plea first,
Yes,
and
Judge.
then you're hoping to get.
Yes, Judge.
See, the problem is that if we were to put him on probation and then they don't give him an immigration bond,
You
what
can't
do we do?
comply with it.
Right. We're setting him up to fail. So I don't know,
Okay. So would you recommend that?
If you want a bench warrant, I'm happy to do it, right? It doesn't matter to me, but like I said, one of the first things that I would want to do is I would want to do a TRAS to see, because I don't know him. How do we go forward? So that's why we have the clinicians interview him. They determine what the best route is. And then if you want to do that, we can.
Do you recommend that we try and do the bond hearing first?
But they're not giving you a bond hearing, right?
I don't think they're gonna do
Does
it.
he have an immigration lawyer?
Yes, we're representing him in the immigration suit.
I guess just bench warrant him, and then we'll try to figure something out.
So, Judge.
Yeah. So if you want to ask Victoria, we'll get it done.
Thank you.
Yes, sir.
Any excuse?
Yes, sir.
Judge, hold on, before you leave, there's an attorney that's in the waiting room.
Okay. Ms. Beck?
Who?
Is it Celine Beck?
Yes, Judge.
Okay. Oh, yeah. I haven't seen her in a long time.
In the queue.
Good morning. How are you?
Hey, buddy.
If you're banging on the door, you got to be careful because you break something, you're gonna catch another charge. So be careful banging on those windows because they break very easily. All right. So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm going to have them read, and we're going to do probable cause to see whether we're going to go forward or not. Okay? Okay. What happened?
On January 10th, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle handcuffing the defendant due to him pulling away. The officer began to roll around while on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands, and the defendant continued to refuse.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted. Right?
So,
Yeah. Just losing?
So, Your Honor, in this case, to read the full dim, it was the disturbance call, and they said they observed him standing outside the above location, being told to leave, and they observed him verbally refuse, and then.
Right, but then cops get up there.
themselves, And then they observed him begin to walk away, and it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and.
Didn't say that.
That was in the complete dims, Your Honor. And then it
Do you know
says.
about that?
And
Yes,
aggressive
Judge,
behavior.
but
Okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance. Somebody's asking him to leave. They're yelling and screaming at each other. Police coming up and saying, "Hey, I'm the police." You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement I smell marijuana. You look intoxicated. Because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on if he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got in your sworn statement is, we identified ourselves as police, so what? Everything that happens after that is fruit of the poisonous tree.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, I'm the police, stop. We don't live in that kind of society. I'm the police, I need to investigate you, so therefore stop all day long. I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter all day long. But hey, I'm the popo.
So the reasonable suspicion we have is they begin to investigate what?
So
A criminal trespass.
they're called, yes, a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw.
So
signs.
the trespass investigation ceases because he's leaving. Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating a trespass, right? I mean, for all intents and purposes, isn't that what it is? The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to.
Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred, to determine,
He's leaving.
He's walking.
He's leaving, right? It's like, here, let me come and mess with you more.
That would only.
Right? So it's like adding fuel to a fire.
But they would still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to mess with him.
Well, they're going up to investigate what they saw, him refusing to leave, and he
leaves.
He only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't be, it wouldn't undercut their ability to investigate what they had observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know it was a trespass, it was a disturbance. We don't always specify the disturbance.
I'm gonna find no probable cause.
You understand?
Mr. Jones, be careful, man. We have enough drama in this life, don't we? You don't like to wear orange, do you? Be careful where you go. Be careful what you do. Everyone's always out to get you, man. Don't let them. All right, man. Good luck.
Thank you. Unless you.
Thank you. Hear what happened?
She said you'll be.
Thanks.
Judge, can you sign the
Judge. Hey, how are you, man?
Very good, thanks.
Talk to me.
Always pleasure to be in here.
You as well.
Thank you, Judge.
What's new, man?
I have a gentleman who's on bond in your court by the name of Corey Bob, and I don't know if you can hear me. Last name B.O.B.
Okay.
And for his bond conditions, Judge, you issued the order for him to have the interlock device. And he did a non-driving affidavit, but he has since bought a car and wanted to know if he could get the interlock.
Yeah, just let them know.
So it looks like they sent
Ramona, are you talking to us?
Oh, sorry.
Enough drama in our lives. You know what I mean? So just talk
You didn't want them to
good.
send a return to your address, Judge? That's all I was told.
Thank you, Judge.
Thanks.
Very much.
Hey, counselor, you ready? Come on. Good morning, sir. Do we have a plea or what do we have?
60 for 20, and then that wasn't interest. I they don't want that.
We'll take care of it. You were Mr. Duger.
Yes, sir.
Mr. Duger, you're charged with theft. You are facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 60 days in jail with credit for the 20 that you've done. You need to understand that this charge will go on your record Isn't that right?
Basically, this would be 3 for 1 credit, so this will be times.
Shh. Yes. Yeah. I mean, from what I understand, it's 3 for 1. So yeah. Right. But the bigger thing is this now makes at least 2 thefts for you. You pick up another theft, you could be potentially facing a felony charge where you're looking at years instead of days. Do you understand? You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off. This is what you want to do. How do you plead to the offense? Are guilty or not guilty? I'm going to find you guilty. I will follow the agreement. It says here that you have a prior assault from 2020. Is that true that you had that? Well, no, you got to. Yeah. Is that true that you had the prior assault, sir? Yes, sir. All right. True to the enhancement. All right, sir. Good luck. Thank you, sir. Thank you. Mr. Claggett, what's up, man? Hey.
I'm here on Mr. Brian Rivas. He's on docket. He's not here today, Judge. So that's why I'm approaching. Because he said he was unaware that his appearance was required because he bonded out. He was in jail the last time, bonded out.
He's supposed to be here. You know what I mean? He's got 4 open cases. And when they let you out, they give you paperwork saying, hey, dude, you got to be here.
Right. Only thing I would ask if you would allow him to come Tuesday when his
Tuesday? No. I need bond conditions. He's a dangerous dude, man. Right?
Oh, he POM, and
Let me see, hold on. So interference, POM, aggravated assault with a deadly weapon. No.
I know.
So what I'll do for you is I'll SFBF tomorrow.
Okay.
If he doesn't show up tomorrow, I'm gonna yank it. It's at 10,003 now.
Okay.
I'm gonna match all his felony bonds. You gotta let him know.
Okay, so he has to be here tomorrow.
Yeah.
Okay, no problem, Judge.
So SFBF mañana.
Okay, Judge.
Ms. Beck.
You're welcome.
Good morning, Judge. How are you doing
Hey,
today?
how are you?
It's been a minute.
What you got?
I have a motion to substitute on a case that was filed recently. Let me get you a case number, Judge.
What's your cause number?
Give me just a second. I was grabbing it. I had it pulled up and then I got pulled back into another court. So I apologize. It is 2547941.
2547941?
Yes, sir. Austin Mitten is the client.
45794.
Yeah.
The motion is in your kiosk, Lauren.
Yes.
On Benton, right?
Yes, Judge, it is.
Okay.
Motion to substitute.
All right, I'll sign it for you now, Ms. Beck.
Okay, Judge. And I had also filed a motion of in bond conditions. He was arrested on an ag assault as well. And I was trying to see what we can do to get those conditions mirrored. Because in the felony, he's ordered to have no harassing contact with the complainant. And in this court, he's ordered no contact, but they have a child in common. And the complainant has since moved to Georgia.
I don't know. I mean, I need to get a RIP done because he's also got an aggravated assault, right?
Yes, Judge. And I
Yeah,
had
there's
emailed
more things that
prosecutors
I
about
don't
it. Yeah.
I don't willy-nilly,
Yes, Judge.
come by, let's talk, and then I'll have them reach out to the complaining witness and then we can go forward with that, okay?
Will do, Judge. Thank you so much.
Yes, ma'am. Okay,
Before you leave, Judge, can you do the no PC form for
I did. Hey, what does Court 10 need?
Judge, they need you to, but they have a small docket, so it's not much to it.
But
They said they had a warrant.
I can take care of it, Judge. We can chain them to a table.
shush, Channing, what's wrong with you, man?
Just kidding. Do you want me to sit with them?
Hey, love, I gotta go to another court. Do you wanna come with me or do you want to stay here and just watch the iPad?
Yeah. Okay.
Okay, just kind of watch it.
Okay.
Okay, I'll be right here. Have a Skittle, love.
No.
Here, want a Skittle?
Yep. Or you want a lollipop? I got it. Good girl. Do you want a soda? You want popcorn? He's drinking milk. Nerds? Gummy bears? No, you mentioned. Okay, tell me the world, okay? Want a card? You wanna watch your iPad? Okay, yeah.
Victoria, I don't know if he told you, but Lumiere, did he tell you that? Judge kind of might be seeing this thing. Okay.
Judge said it, please fill out the form.
He just left the form, but I'm probably gonna just put it in his queue for you.
Yeah, we'll just have to remind him.
Because I have to try to get out of here. Let's check.
Right, LaShawn, he's on his way.
Sorry, John. What's up? Yes. I've seen Jason Wall running.
I have not.
I got the guy. Oh. Danilo with the parent. The mom scene is a famous guy. You know what it was? 5001? I don't know.
That's great. I promise I was listening, but this was on a small flight. Yeah.
Oh.
Okay, but so it's, so if he said there was stuff that was wrong, it's a secret, we all know it's a secret.
Because just didn't do bad.
So I'm like, just didn't. It's good.
Sorry, buddy. Sorry, buddy. I need to check this out real quick.
The last very good.
I know, but. Okay. I need to see what's going on. This is, you know, it happens. So Galino, and then you write down numbers, he did 3750 and.
Yes, that's right. Pay back. But also I went on Facebook. I graduated.
They're straight order, so. That's why I paid high enough, getting up everybody, you know. Yeah, I want to get money. No, I like, not yet. Congrats on the, don't cheat, just kidding. And this handsome man is a Tulanian.
Yes.
You heard today?
Yes.
You're bragging. No.
I don't know. Yeah.
So you're the chief engineer? Or you're the chief engineer? You're the hurting cat. He's a good lawyer. So see the shot day around. Well, he's a good guy. That's right. Now I'm looking for Jason. See you all later.
The only thing that
Trying to raise money for the.
No, we need a vacation. Oh my God.
So. You take it home, put it on the bridge.
That's
The criminal history.
Oh, yeah.
I wrote down all three, but I need to do the best. Cause there's a. My client said this. Was he here? Yes.
Oh, no, you can't.
Like if they're interested. No. And you sent it to the email lady.
That's why I was.
Yeah, but there's some.
These two things.
Yes. No. But this is my idea, so great. And Barnes is great.
All right.
Oh, I thought you had something.
I'm really, what you could have.
Oh, where's my end?
My dog is over. I gotta get these things out of my dining room.
Yes.
My wife's got a lot of it's like. Yeah. So I think there's a judge. I wanted to check about the. The other two were Franklin and Jefferson. Jefferson was, I'm over signed. Franklin, Landon Franklin, he was, they were having a hearing, I think that was,
Oh, the knife? Is that one? Just. He's a little. Where do you have?
I don't have any.
Last order.
Yeah, sign anything.
Just putting on the other one.
Tuesday, I've seen.
What's result of them?
No, he was gonna only know he's seen, Brandon, Terrace, because he's gonna, he did have a lot of fun.
That might just.
Have
It might just. Have you asked them? I don't know.
Chart.
Yeah.
Let's check it out.
Does that answer your questions?
Yes.
Yeah.
Just went back down to. 8 o'clock.
Now I know where to go when I'm. I heard y'all already bought it.
So. Well, yeah, but if the law commission can get right. Oh, well.
Oh, we're doing.
Right.
Oh, yeah. No.
It's not a violation. Yes.
One more.
Yes, please.
Oh, yeah. No. It's gotta be, one most camera lights, sure. And,
My daughter has a kid who has 4 weeks.
seriously,
Mhm.
really, it's a weird one.
And it's his first name, so.
You really, it's my middle name, but I always like, yeah.
Well, you know, sometimes dad will name their kid.
Oh, yeah.
They don't know, so that's all.
So my son, I mean, the three was Charles.
Oh, I see, I see. No, his Blaze is his first. Well, you know, my daughter's 4, so maybe maybe Blaze could be the middle name, because I said, is his first name? Blaze? She's like, his first name. They actually like laughing.
I
don't know where that came from. I don't know, it's okay, we all have. No stress, we're all the same. Franklin, Judge Fleischer, are we resetting?
Yeah.
No, no pressure, I just need to.
It's gonna be like my Zelle, my email, Zelle, I don't have my phone number. Yeah. Can make
No problem.
No, it's okay, I just want.
You do what you gotta do. Jones. Oh, I think that was the last one. So.
Roll to last Monday.
February 24th. Yes. I'm trying to get a hold of Mr. Nolony for, the fitness part. I'm trying to get a hold of him. I emailed him twice and I called, and the voicemail page is up, it says they can't answer. So if y'all can get a hold of them.
Yeah, for sure.
So.
That's how I ignore them.
Okay, thanks.
Thanks.
Without the artwork.
Okay, thank you.
So she has it,
Mine's still sending to, but I'll.
but yes, it's in, it's in the.
Someone's got it.
I understand, I'll
I assume they're gonna.
send a
They'll
picture
trust me,
next
that's
time.
it, there's no options, so.
Here's the. It's the only time I ever plug in my laptop, right? It's storage there. Sure.
Yes.
You guys tomorrow. Sorry.
Let me watch and think,
Oh, yeah, I will. See, progress they made today.
That's, get back, it's gonna take a while.
Yeah.
If not, a week back.
Still listening.
I don't think I've ever seen that much. I mean, you need it. Stuff.
I know, it's crazy. Good luck, let me know if there's anything that y'all need me to do between now and tomorrow. Okay.
Thank you so much.
You're welcome.
I like that.
Me, yes, sure.
I usually make videos where they just kind of.
That's cool.
Yeah, just so you know. They participate. We'll make them walk around. Try and bring it.
I'm gonna put it up towards ten.
The well garden.
I'm going to harass them on that day.
That's still around?
I'm standing in this Thanks for coming. I think we kind of feel it. He's always there, so surprised. Something was up. All right, so it is discovery complete and this is going to be a lot more differently than it normally is. So I'm trying to take it as a normally.
I'll have those.
This is the first week where I'm like.
All right, let's take care, bud. Take on. Thanks, guys.
Yeah.
Yeah. I just shared it. I will look back to
I think from the machine does.
Yeah. That's a good guess. Yes. But I don't think people are anyway.
And they know, I've seen. I can see it, she'll be right with you. You go on now. All right, yes, you know. It's just a process. Did they provide an large. Council thinking about discovery and then statement that it needs. You did it? You've been moving her. Yeah. You can go ahead and have a seat and look. It's like, okay, there are not, all of us invited for miles.
Yes.
Chief, you're in multiple books? It was on five. Oh, Amber?
Yes.
I love her.
Yeah,
She's great. She's great. Oh, yes, I do remember her now telling me that she's like, she's going to court.
Yeah, she's.
Yeah. I heard things about Judge Fleischer. Yeah, that's what I hear about, because, like, when they're there, you can start off, but like, you know, yeah. Yeah, that's a good court.
Yeah, like we have trials. Hearings.
And I looked at, I'm here, young camera. No, I thought it's Olympic. Hey, I really felt recognized one time at work, Christmas time. And someone was like, oh my gosh, I love Alicia's hat today. And I was like, I saw that someone sent me a screenshot of the comments on it, and it wasn't somebody I knew. And I thought, wow. Yeah. They should retain them. Does it freak you out that well, it's like Judge says it all the time, so like, I understand why, but it was a little strange.
Yes. Is it in back here? So I got a silver all day. And just a little, they are offered. So, as far as the year, yeah. He's in he's. He did it like this. Yeah, he did it like this. Jobs. Oh, no. It's big, but it's just that it's changing. I'm not gonna do anything. She got air conditioning. It's a bunch of April 14th. So
I do it.
Yeah.
Hey, while you're going up there, can you check for boxes? I'm like, oh, I don't know. I don't know why we don't. It's kidding. Yeah. Yeah, I think I mean, my fantasy experience on this, but everything I honestly, yeah, no, if that's gonna do good. Because if the case or something. The best is. Yeah. And then I had a question. I mean, I can try and have, and I'm just looking at these. Go to grocery, but I'm not.
Hey, what's up? Yeah. No.
No, I think my son is. Not. Yeah.
What's up? All right. What's that? Well, I have Everly Hassan, who's on the docket tomorrow. And this is a gal that
I need to check with the fee trial on and see how she's doing.
Who is it? Is she she's
Everly
on
Hassan, she has a scram device,
and she's on docket?
tomorrow.
Tomorrow. Okay, what's the cost number?
Cause number is 2491433. Yes. But she's living in California. She's on this kids as far as money is concerned. Pretty sure that it is affected by some shutdown, but she's broke. She doesn't have enough money to get back to Easter.
You said 2549?
2491433. 2491433.
I don't know where it's 2491.
Yeah.
233?
433.
I'm so sorry.
2491
I
433.
don't know why that was, okay.
2491
My
433.
apologies. She's on PTI, so you would have to check with probate for her screen.
Oh, okay. They have the scram. Hey, I'd like to check my car. Get a scram report. Make sure she's in compliance.
She's on.
She's up in PTI. Everly Hassan.
Do you write them? Do you have your, copy of your nothing said that you?
No. You're gonna reset. Tomorrow. I didn't know what case come back.
It's late, so I have to tell my wife that I need to go over the judge. And it's an arraignment that's out here, so all are.
Perfect, thank you.
Awesome.
All right. We'll see you all tomorrow.
See you tomorrow.
If you could leave one of your hostages behind.
Sure.
I just need to approach the judge about resetting the case. You may very well say no. But the song person there trying to get over. Yeah. And she contacted me, she's like, I have no money to get down. So she did PTI. So she lost her job. She got behind on, I don't know, maybe did everything. She came in and she was trying to get caught up. She was gonna try to get a class done. And she just seems like, I just feel like she's given up, I just don't her. I don't know what to do, and I 100% understand that. So, I don't know what to do. You know, yeah, it's passed on tomorrow and say everything out, and that's also.
No, the reset.
Oh, also. What I'm noticing is Judge guys really wants to see them complete whatever SOBI, seems to be the goal.
Yeah.
But unfortunately, you know, some of that takes money.
Yeah.
Which we don't know. So we say that she was qualified, but she can't further.
Much higher.
But anyway, so I'll see if I can get more time, that's all I can do.
Yeah.
And, not, then she'll have a month.
I have to.
Yeah.
Sorry, no one else.
Oh, no, how you doing over here?
Yeah, I typically, I don't think you're allowed to do that.
Yeah. Sorry.
I do not. I would do that.
I'll be back though. Same old deal. You get your, yeah, just to get through. We're trying to. Yeah, tomorrow. Say Friday. We're trying to get. We're trying to. Right.
She just needs to be recording. Losing health.
It's not on the same because she's the.
She has a strap.
Yeah, no. It's not, so, I mean, she was on PTI, she was taken off the 28th.
But she's still on bond.
So, yeah, but no conditions, if you want to say ATI, we can charge them from, commissions. Plus,
Anybody? Nobody?
should have been PTI, she was in August.
Yeah.
And we haven't been supervising her since August.
It's a weird little rest. Right. That's strange. Well, she was supposed to be here tomorrow.
So, I'm sure, I wasn't here enough to years.
Yeah, this is a match. As we've said. The technical legal term that is CMS. We grab some.
Almost forgot the ball. Must have was my thought.
Smile lunch. We can hang out.
Yeah.
Oh, pretty good. He's over at Helping Fort Chan, right? Yeah.
Abigail, are you gonna stay till Judge?
Yeah, I'm staying around.
Okay, thank you. Do you miss court three?
Honestly,
too warm to be out. You don't have to ask that question. That was a trick question.
I miss my cases more than anything, because I was there for a long time.
I
That now I kind of feel like, oh, I just handed this off to someone else. So it's a little adjustment, like getting used to all the new ones in the trial docket.
Is Lauren still there, or did she finally get moved?
She's still there.
Oh, okay.
Yeah, so she's there with Gracie, who I don't know if you met.
No, okay.
I don't know when you were
I
over
remember
there.
Lauren was there for the longest. I remember you were there.
Yeah, Lauren and I came in at the same time and she's still there, so.
Yeah.
Text message from a client. Do you have a SPIN number? If so, what is it?
Do you need to know? Go look it up.
Do I have a SPIN number? Thank God you wrote it down. I don't know. I think
Sometimes we
maybe-
use it like trial. That's like the only time I ever see people use it is when they're in jail and they're making calls. We use it a lot for like, for pretrial. Like if they come in, they can give us their spin and what their case number. We work a lot on spins to see.
Oh, you scared me. Sorry. Why'd you come up here? Oh, because your judge left and needed to sign this. Judge left. He hasn't come back up here, was he?
He's on his way back.
Oh, okay, so he also I beat him too.
He just went home.
He did. He can't cut me. Oh, okay. Yeah, right. I forgot to put that on the bench for him to sign. It was, they came up and talked about it.
He's here.
And the attorney gave it to me. And as soon as he gave it to me, Judge was like.
Probably gonna ask if how old the case is and if the.
No, he was there. He heard it.
Oh, he already, oh, so he wasn't assigned, he just didn't get.
Yeah.
Okay, cool, never mind. I'm probably, yeah, there he is, there you go.
I found them.
All right, my love. Hey, are you almost ready to go?
Yeah.
Let's go.
That was a motion for that
I have
defendant
the-
judge.
Man, how'd you get here faster than I did, man? What the hell? What? Man.
I
was trying to beat you too. No, that pad.
Oh.
Mr. Butler.
Hey, what's up?
Hi.
Good to see you.
You too.
Everly Hassan.
That's the case from she's in
She's
California.
in California.
She's in California, yeah.
Called me the other day. She's freaking out. She's broke, has no money, no way to get here. Asked me, begged me, could I try to get the case reset?
It's on.
You have a scram on her. But we don't.
I don't even know what's going on. I mean,
So this is a case that
isn't she in the PTI and had to violate?
she got
regulations?
kicked out.
What's the case number?
Oh, she got kicked out.
I'll give it to you.
Oh, she said today's plea or trial.
Tomorrow is her court date.
Her spin number is
24, which one do you want? Case number is 2491433.
431?
433. 24
91433. So we're trying to do a time serve so she could get the hell out of Dodge. That's what we're trying to do.
Right, but we need her here to do that.
Yeah, and so I just need another court setting.
But when is she supposed to get here?
She asked if we could do the first part of next month. Like maybe like the first of the week in March or something. Give her that date and.
Okay, I mean, I'm happy to SFBF the first week of March. You know, you pick it, but if she's not here, I'm revoking.
Understood. I appreciate that.
You can't just keep, you know.
No, I got it.
So, yeah, I'm happy to do it. Ms.
Thursday the
Butler.
6th.
Sure. Yep. Yeah, but come hell or, you know, high water, she's not here.
Great movie, by the way.
You want a Skittle?
You can move it up. You can
Here.
let the judge know. I would,
Has he ever said
So
no
just
to
hold
that
it, right?
question? You want to skittle?
Yeah.
Baby's sick, so he said.
Okay.
Okay, yeah. Yeah, that's right.
Thank you.
Of course, Mr. Butler.
All right, I got you down for March 6th.
Thank you.
All right, thank you.
Of course. Are you ready? What,
Yes, Judge.
any be?
All right.
Go ahead. Put them on the fridge.
There's something new in the street.
So, yeah, we're keeping those papers.
It wasn't me, I swear. Okay.
It's kind of like a bootleg. It's Travis misspelled.
2501.
Yeah, it's like yesterday.
I think I need to do a bail order on the guy that I revoked. What was
And
it?
a no PC.
I did an OPC on Jones.
On Franklin, on page 10, you didn't write it down for the criminal mischief, and we wanted to confirm because the state wasn't sure if you were going to OPC, because you wanted to do a hearing instead on.
No. I found no PC on the mischief. Yeah,
Okay.
for sure. No PC.
I'll get that in your queue.
Uh,
And then the bail order was either on Galindo and Gomez,
Gomez, that's it. Gomez.
and there's the BBR for Gomez in your queue?
So Gomez, we set it at 3,751.
Yeah. And then, yeah, BBR for, is in your queue for Gomez.
Yeah, well, for our phone number, it's like, and then those are the last. So for the number, they shout out, and we just send that back. I don't know, they're really- So they don't think it's-
Okay, Vic, who's next?
That's it, Judge. We're
Oh, that's
done.
it. Okay, so. I like our new chief. I think he's good.
Yeah.
He's easygoing, he's nice, and he's not, I like,
He's here early.
does he?
Yeah.
Okay, everything's signed in the queue. Is that it?
Yeah.
That's it? Okay. Yes, let me look to see if 10 needs anything signed or sign on.
There's anything- Oh, I think, yeah, I think it's on.
Let me check it.
I don't know, but it's not part of the template and stuff. I keep just on it all. So there is obviously.
Okay, that's it. All right. See, I had to give a shout out to Angie D. From yesterday, Angie D. Give her a shout out.
Andrew D.
Yeah.
Thanks, Jared.
All right, we're done.